All right, greetings. Good morning or good afternoon, good evening, wherever you may be. Welcome back for day 2 of the 20th International Wildlife Law Conference. I'm Roy Gardner. I'm a professor of law and the director of the Institute for Biodiversity Law and Policy at Stetson University College of Law. And on behalf of Aaron Okino and the entire Stetson community, we very much welcome you to this conference, and again, we thank everybody for their flexibility in adjusting as we move to an online format. A few housekeeping notes. We are recording the session. If you have questions, please enter them in the chat or question box. You can unmute yourself, or we will unmute you if you'd like to ask the question yourself when we get to the Q&A and discussion portion. Or if you'd like, we can just read your question to the presenter. We do ask you, however, to identify yourself if you are asking a question. And if you are not speaking, please mute your mics. Today we're going to be a little strict on the timelines. So we have, Aaron and I have a hard stop at noon as we have to shift over to the International Environmental Moot Court Competition, which we are also holding online. So we may have some students joining us for that right now, and then we'll be hearing their arguments a little bit later today. So yesterday, we covered a wide range of issues, but there were some common themes or threads. Paul Boudreau opened with a lecture on species in law, contrasting the scientific approach to classifying species and the goals and objectives of legal definitions which may not align with scientific classifications. And this definitional issue was a continuing theme throughout the day, especially as we discussed climate change and invasive alien species. For example, Richard Cadell examined the challenges of fish stocks shifting due to a changing climate, and that led to a later discussion on what should be considered an invasive species when a species range shifts due to climate change. And not coincidentally, that's actually the issue of this year's International Environmental Moot Court Competition. We picked that up from last year's International Wildlife Law Conference. Climate change was a continuing touchstone as we ended the day with Will Burns' presentation on carbon dioxide removal approaches and their implications for wildlife. He also examined how multilateral environmental agreements are considering, or not, these issues. And if we do move forward with ocean fertilization, one of the carbon dioxide removal approaches, it would be quite instructive to return to Mark Campen's thorough review of how UNCLOS's International Tribunal for the Law of the Sea has treated the precautionary principle. Another theme yesterday was health, human health and wildlife health. With respect to human health, Dr. Qin provided us with a thorough review of China's wildlife laws and how it is moving to incorporate public health into the calculus. And he also noted the gaps and challenges that remain. And with respect to animal health, we had a very interesting panel on animal welfare issues, from hunting and harvesting to what happens to trafficked animals that are confiscated by the authorities. And finally, I want to note Ari Trauborst's excellent form and biodiversity lecture on domestic cats and international wildlife law, and how cats can be seen as one of the worst invasive alien species. It was fascinating, not only because it re-examined a familiar object through a different prism, but for the response it engendered as well. Consider the anger, vitriol, and threatened violence by some members of the public because of the suggestion that perhaps we ought to change our behavior, that is, keep cats indoors to benefit wildlife and biodiversity. It's a simple step that could have a great positive impact, but the reaction was resoundingly negative. Is this because cats are a special case, or is this just a normal human reaction when confronted with change? And perhaps that's something to keep in mind as we move through the rest of the conference today. And today we're going to be focusing initially on wildlife trafficking and issues related also to trophy hunting. And so we're going to start off our presentations with Professor Linda Malone. She is the Marshall Wythe Foundation Professor of Law and founding director of the Human Security Law Center at the William & Mary Law School. She received her BA from Vassar, her JD from Duke, and her LLM from the University of Illinois. She served as a law clerk for Judge Wilbur Pell of the U.S. Court of Appeals for the Seventh Circuit and has practiced law in Chicago and Atlanta. And we're really delighted that you could join us today. And I'll now pass the controls over to you. Thanks.
Thank you, Roy. You hear me and everything is all set, right?
Very good. Yes, thank you.
Great. Just two quick preliminary matters. I listened in all day yesterday, and I just wanted to say how much I enjoyed and benefited from each and every presentation. So for those of you who are still on today, listening in, I just wanted to let you know that, how much I appreciated it. And then I really want to do a hats off to Roy and to Aaron. They have done a Herculean job of managing to keep this conference going. And it's one thing to plan a conference initially online. It is another thing to turn on a dime and make an in-person conference an online conference. So bravo, that's all I wanted to say quickly. All right, wildlife trafficking as the crime of pillage. That may sound like a very archaic term, pillage or plunder. But I'm trying to make the case that wildlife trafficking should be prosecuted before the International Criminal Court as a war crime. And I will try to give the reasons and how it could be done, but also the reasons for why there might be a need for it and what advantages there might be from that. I'm sure I don't have to convince this audience about all the harms from wildlife trafficking. But even those of us who are familiar with its harms, it's constantly amazing to me the magnitude. It's estimated that wildlife trafficking is the third most lucrative illegal enterprise, only behind trafficking of guns and drugs. When I look at that, I think, wow, if you added human trafficking into that, we might have a different priority. But the magnitude of the problem is very severe, and we're now experiencing some probably not anticipated consequences of wildlife trafficking that are hitting home with this particular virus. Again, with this sophisticated audience, you probably recognize what this strange-looking creature is. It is a pangolin, and it is, to my surprise, the most highly trafficked animal. And it is the most highly trafficked animal because apparently its scales are used for medicine purposes, medical purposes. Its blood is drunk as a tonic, and its flesh is eaten as a delicacy. And I bring this up in the beginning because obviously in the difficult circumstances that we're all going through worldwide, we are looking for some kind of solace somewhere, some kind of silver lining. And one of the silver linings possibly is that this virus may be saving this animal because China has put in place a ban on wildlife markets and commerce in wildlife meat and to some extent medicine. I was extremely interested in what Dr. Ken had to say yesterday about the Chinese parliamentary directives and how they might be enforced or need to be enforced. And this is a consequence. We still don't know where the virus came from, certainly, for sure. But one likely possibility is from consumption of wildlife meat. And this brings a whole new dimension to the question of prohibiting wildlife trafficking. If we're not invested in it for the sake of the animals, we might as well be invested in it for our own selves. Now, turning to the laws of war, which might surprise you a bit in terms of the context of wildlife trafficking, we've seen many examples over time of war crimes based on the theft of resources and destruction of cultural artifacts. What you see there is the very beautiful former Al-Nut line in Palmyra, Syria. And ISIS, of course, has been brought up a number of times for this kind of cultural destruction. And it is recognized as a war crime to destroy objects of cultural heritage and cultural significance. So that's well established under international law and under the various conventions. Also, we've heard quite a bit over the years about blood diamonds and the exploitation of resources, primarily mineral resources, in countries that have conflicts, armed conflicts. And so much of what I'm going to build upon is the literature that has been developed with respect to responsibility for those kinds of exploitation of resources, mineral resources, as a war crime. But what I want to try to do is to show how that can be used in the context of wildlife trafficking. As I said, it's the third most lucrative illegal enterprise. You see some of the numbers there, you have the picture. It is obviously a very extensive problem. So to start with the legalisms, I will explain later why I think it's important that we look into using the International Criminal Court for these kinds of prosecutions. But for now, let's just see what the possibilities might be. The elements for plunder or pillage in the Rome Statute of the International Criminal Court are found in Article 8.2b that you see there, 16, of the International Criminal Court elements of crimes. And those provisions are that plunder may be prosecuted when the perpetrator appropriated certain property, the perpetrator intended to deprive the owner of the property and to appropriate it for private or personal use. The appropriation was without the consent of the owner. The conduct took place in the context of and was associated with an international armed conflict, and the perpetrator was aware of the factual circumstances that established the existence of an armed conflict. So I want to take a look at the most difficult of those, perhaps in terms of legal arguments that there is coverage for wildlife trafficking within that definition. What we know from the Rome Statute and the elements of crime is that property protected by the ban on appropriation, quote, is not limited to civilian property. So that's extremely important. And I'll come back to this because historically, we tended to think of the war crime of plunder as the situation of sort of a soldier in the field during an armed conflict who takes private property from an individual for their own personal, for his or her own personal benefit. That's historically the way the prosecutions have occurred, but that's not the limits of the offense. And so that's what I'm trying to explore. That it's not limited to civilian property is significant in a wildlife context, obviously, because wild animals are not considered civilian property. they're considered a lot of different things, as I'll get to later. Going back to the question yesterday about what is wildlife that we saw in the discussion with the feral cats. But for now, we just know it's what it's not. It's not civilian personal property if we're talking about wild animals roaming. Appropriation is not defined under the statute or in the elements of war crimes. It's one of those situations that we frequently encounter in international law where what would seem to be the most important term to have a definition is not defined. Presumably because there could be no agreement reached, or if the idea was to wait and to see how it developed, or whatever it might be. But that leaves us sort of wide-ended and open on that. Private or personal use, those terms are also not defined, but I would argue they should be construed broadly enough to include cases where the property is given to third persons and not just used by the perpetrator. If it's for private or personal use, whether the person benefits from that thing is more likely to be by virtue of selling that thing, even in the most historically traditional types of cases. So I don't think it's too difficult to surmount that kind of limitation. So let me first focus on rebel groups in armed conflict areas. And in order for it to be a war crime, of course, there must be an armed conflict. And it can be international armed conflict, or it can be non-international armed conflict. So again, looking at some of the academic arguments that we have seen and some of the more recent precedents, scholars have presented strong arguments that the traditional narrow notions of pillage should be expanded to encompass a broader and more systematic context. And under this definition, rebel group leaders who themselves may not have captured or sold wildlife could also be held responsible as perpetrators of pillage. And there's several different theories on which that could be the case under international criminal law. So we're not trying just to go after, or would we necessarily want to just go after the impoverished individuals who are often the ones that are killing or poaching the animals or doing the mining for the blood diamonds or whatever else it might be? That's not, I think we can agree, where the efforts need to be placed, which is part of the reason for arguing for this kind of prosecution. And prosecutors could show that the defendant intended the property for personal use by showing, for example, that the group transported or sold the poached wildlife and used the revenue for private gain, and private gain in the broad sense, such as to purchase weapons, pay troops, or enrich themselves or their larger organization. I don't think that personal use necessarily means that the rebel group put the money in their pockets directly, but that in some way they enrich themselves or the larger organization by virtue of the wildlife trafficking. Now, in terms of trying to reach some of the higher ups in the chain of wildlife trafficking, beyond direct prosecutions for pillage, there's a compelling argument that can be made for the successful prosecution of rebel group leaders under an aiding and abetting theory of criminal liability. And under international law, we have some variations in what are the elements of criminal liability. But for now, I'm just going to focus on what the Rome statute says. And it says a person shall be criminally responsible for a crime within the jurisdiction of the court if the person orders, solicits, or induces the commission of such a crime, which in fact occurs or is attempted. And that the person will be criminally responsible for a crime if the person, for the purpose of facilitating the commission of such a crime, aids, abets, or otherwise assists in its commission or its attempted commission, including providing the means for its commission. So that enables the possibility of prosecution of those higher up in the supply chain for aiding and abetting the commission, even though it's really sort of the reverse that we think of in domestic criminal law, that the person who is aiding and abetting is the person who is lower on the criminal chain, if you would. What this does is allow us to proceed up the criminal chain to try to get those who are really the masterminds of the poaching. Now, the reason, for those of you who may not be familiar with the laws of war, the reason I started out with rebel groups is because the legal issues are different when we talk about rebel groups in armed conflicts and when we talk about government actors. But obviously, it's not just rebel groups that tend to benefit from exploitation of a country's natural resources in order to gain an advantage in armed conflict. So rebel groups are always clearly appropriating property from an owner outside that group, from a private individual, from the public sovereign, or some combination of the two. The question arises that government actors are not appropriating at all from someone because the trafficked animals or animal parts are already owned by the state. Now, the question of who owns wildlife could be a extensive analysis to begin with, but I think we only need to explore it to a certain depth for this purpose. It depends, of course, on the factual circumstances. Although most legal systems around the world address the issue of wildlife ownership, there is no consistent system of which I'm aware. Some wildlife is owned by the state, either as a rule or because wildlife occurs on state lands. Other country wildlife is just owned by the state, but this ownership may be vested in the government on behalf of and for the benefit of the people, so we get into public trust concepts. In other countries, such as Zimbabwe, which is interesting because my understanding is that Zimbabwe is the country where most poaching occurs more than any other country. There has been an elimination of the distinctions between private and public ownership. But the point that I want to make in this context is who owns property for purposes of prosecution under the ICC does not have to depend upon any particular domestic interpretation of ownership of wildlife. Perhaps if you're looking for some general principle of international law that says who owns wildlife, that might be relevant to decide, what prevalent view is there, and as I suggested, there may not be one. But in terms of interpreting the Rome Statute as a treaty, I believe that the question of ownership could be interpreted in a way that would carry out the purposes of the pillage provisions under the statute. And that, I don't think, would depend upon any particular domestic determination, and would open the possibility to government actors who, in my view, are essentially appropriating from the people the wildlife in the territory for their own personal benefit, their own advantage in an armed conflict, that could come within the definition of pillage. Another possibility that has been explored in the blood diamond context is the corporate approach to prosecuting pillage, with the goal of extending criminal liability to corporations and other purchasers of materials stolen during armed conflict. So this isn't necessarily somebody that is involved in the process, the chain of the criminal enterprise, but may just be a knowing purchaser of materials stolen, or being a negligent purchaser, perhaps. On this model, the elements required for the crime of pillage are met: appropriation, intent to deprive, lack of consent. But in addition, for this corporate enterprise liability, we have to go back to the aiding and abetting liability. and apply that to the corporation in question and the corporate individuals in question, so that it's expanded to include defendants who were not themselves directly involved in the illegal appropriation itself, but are criminally facilitating it by being knowledgeable purchasers. A conspicuous complaint against this theory is the problem of how to connect those far removed people or entities to the original theft. It may be that, again, under aiding and abetting principles, that the corporate purchaser or company may be criminally liable only if it materially contributed to the crime and intended that the original crime be committed. And those are elements of proof and evidence, but not insurmountable barriers. Finally, on sort of the legal issues, there are other international conventions that can be used, particularly against the government actors to try to reach the corrupt government officials. There's the UN Convention Against Corruption. Once again, corruption is not defined, but various acts are mentioned, including fraud and embezzlement and so on. So this international convention has some potential applicability as well as another tool to be utilized. The UN Convention Against Transnational Organized Crime for criminal enterprises, again, missing a few critical definitions, but still a possibility of utilizing it in this wildlife trafficking context. Most people tend to think quickly of the Convention on International Trade in Endangered Species, which is really, it is the convention on wildlife trafficking. The difficulty with that, of course, is that it's essentially a trade restriction, if you will, something of an after-the-fact kind of remedy. Plus, it's entirely dependent upon domestic law enforcement, which leads me to the question, why the need for pillage as a crime before the International Criminal Court? I think there's a number of justifications. I mean, one of the most obvious is the magnitude of the problem is so significant. Hold on. Wasn't anticipating that. Can you still see me and see the presentation?
Let's see, you need to go back to your PowerPoint.
Got it. Okay. Why the need for pillage before the ICC? We need every tool, every legal tool in the arsenal to fight the magnitude of this problem. And the Convention on International Trade in Endangered Species, as I said, has a number of weaknesses, which I'm sure many of you know. But since it relies entirely upon domestic law implementation and enforcement, the countries where the problem most often originates simply don't have those kinds of resources. If they do have some resources, those resources are going to be used against those that are low in the supply chain, and not those higher ups, which would be preferable. Hold on one second. And so CITES itself, relies so much on knowledgeable customs enforcement. There's a story, not a story, there is a test that was done by Traffic, who obviously oversees much of what happens under CITES. And Traffic had a crate that said Paraguay penguins that it sent basically around the world with a number of stops internationally. And it was never intercepted. Now, it was clearly labeled. There are no penguins in Paraguay any more than there are African elephants in New Jersey. And so Traffic was trying to demonstrate how much this is dependent upon the knowledge and the training that customs officials are given. So that sort of takes the problem from sites and justifies why we might want to go before the ICC. But there are other reasons as well, which is the ICC is individual criminal liability. And the ICC has certainly had its problems, and it's particularly had its problems with African countries, particularly with a few withdrawals recently. But at the same time, it does bring a focus, a notoriety to the individuals that are prosecuted before it. And with the possibility of sort of going up the supply chain, it raises the possibility of going after individuals who are not just in Africa, but worldwide. And I think that's something that the ICC needs as well. And then also in terms of the advantages with the ICC, it allows a certain piggybacking, as it were, on cases that might be brought on very well-established war crimes or other international crimes cases, and allows wildlife trafficking involvement to be piggybacked on those charges, particularly in the cases of armed conflict. I would give you this example. I'm very familiar with the history of rape as a crime, as a war crime, from the work that I've done. And rape as a war crime, much like pillage as a war crime, was traditionally and historically thought of as a crime that an individual perpetrated on their own against another individual. But as we began to see focus in the International Criminal Tribunal for Yugoslavia on systematic rape, and in Rwanda, and now in the ICC, by adding systematic rape at a time when it may not have been easily recognized as a crime against humanity or a war crime on a systematic, broad-based responsibility basis. Eventually, over time, we have seen the precedents established to demonstrate that. So I think that in many of the high-profile war crimes cases for things like genocide or crimes against humanity, whatever it might be, where there's a clearly recognized international crime, that adding the crime of pillage to those offenses will lead to growing recognition and establishment of it as an international crime. Okay, thank you.
Thank you so much, Linda. That was a fascinating talk, and really interesting to think about different approaches, non-traditional approaches to dealing with wildlife trafficking and new tools that may be available. Let's see, we're going to open it up for questions now. Let's see if any questions in the question box or the chat. Yes. So let's see. So Richard Cadell, did you want to make your comment or intervention, or would you like me to read that?
Hi, thanks for a really fascinating a journey through the ICC, and it's not a forum that gets a lot of attention in this context, and it's been really interesting to see how it might be used. Just a couple of things that fired my synapses really when you were talking about the concept of personal use. It seems quite close to the notion of private ends in piracy and the way in which that's been reinterpreted as being well, anything that isn't state sanctioned, frankly, a la Sea Shepherd and that sort of thing. It was interesting to see you talking about going up the chain and chasing the money. as we see a lot with illegal fishing now going after the financial institutions and the insurers. The question I had, and I think you touched on it a little bit, but it's an interesting way, I think, of reflecting on it, is that the ICC has often been criticized as being developed states telling developed countries how poorly they're doing, particularly in African context, and some really unfortunate echoes of civilization and that sort of thing. I was wondering if this might be one way of legitimizing the ICC in that respect, in demonstrating that often the nexus of a conflict goes far beyond the actual theater of war, and that the tentacles of the ICC could be brought to bear around a group of people that are perpetuating conflicts, or at least not helping the situation by buying and facilitating the trade in wildlife, particularly in the Western world.
Yeah, absolutely. Those are two great points. And I'm excited that you brought those up in this context. But yes, you've touched on, I sort of brushed it quickly, but if we go up the corporate chain, if we can do that, then the individuals who are being prosecuted are not just individuals from the continent of Africa. The higher up the chain we go, we sort of depart from the supply part of the chain to the manufacturing of the demand and the provision of the wildlife. And so in addition to anything it might do with wildlife trafficking, it seems to me it also might be of great benefit to the ICC's reputation. And taking sort of a broader view of criminal prosecution that doesn't make it seem so focused on developing countries, but that it's actually trying to benefit developing countries by going after other state parties and individuals in other states.
Thank you very much.
Thank you.
So, Linda, we've had a couple of requests and a question. So the requests are whether we can make the PowerPoint generally available to folks.
Yes.
Okay, all right, that's great. And then for those of us who are not familiar with the ICC, how is a prosecution actually initiated?
Well, there's a couple of different ways. And one of the reasons the U.S. objected to it was it thought that there was too much discretion in the prosecutor to bring these cases. But from my point of view, in fact, there are a couple of safeguards. I mean, it's not just the prosecutor can willy-nilly decide, I want to prosecute this. And because it has to go before a panel and be evaluated. So without getting into too much of the intricacies, a lot depends upon the prosecutor, not because they have such extensive power, but just because they can initiate these things. And the current prosecutor has been, I think, very impressive in her even-handedness, in what situations she goes after, and also in the prosecutor came out with a statement saying that her intent was to prosecute some offenses that did not normally get pursued in relationship to the environment, which I found to be extremely interesting and very encouraging. So I have also seen her do the same with gender-based offenses. And so I really do see a parallel between those two, and think that wildlife trafficking would fit within the rubric of what the priorities are that the prosecutor has mentioned.
Thank you. Let's see, do we have other questions or comments? Aaron, do you see any that I might be missing?
Let me check.
If not, I have one concluding comment.
I don't see any other questions in either the question or the chat section.
Great. Yeah, Linda, if you would like to, if you have some concluding thoughts, that'd be wonderful.
I have one concluding thought, which is in this current crisis that we're experiencing that is so difficult for everyone, hopefully we'll learn some lessons. And one of them, I hope, is how truly fragile our world resources are. The Earth's not going to end, but we might if we have to have a selfish focus. And you know, we keep hearing we're all in this together. Well, maybe a lot of the skeptics will start to believe that, and with the crisis, you know, the linkage between wildlife trafficking and the current health crisis that we're seeing shows us that we don't even imagine sometimes the full consequences of the damage that we're doing. I'm certainly no prophet, but I'm think down the line when perhaps we're coming out of this a bit, we're going to see another crisis, and it's going to be food, the food supply. I don't want to preach, but this will be my last comment. My daughter works for Feeding America, and they've been overwhelmed by the generosity of contributions that they have received. But she says they're having trouble getting food. And I mean, what are the farmers doing now? Who are their workers? There's, you know, what about the migrant workers they're so dependent upon? So even when we come out on the other side of this, I think we're going to learn another lesson, and it's going to have to do with distribution of food and the right to food, a human right to food and survival in a different context. Thanks for letting me do that.
Thanks so much for those thoughts, and yeah, indeed, there will be cascading effects from our current situation, and we really appreciate your joining us and walking us through the ICC and how this may be a tool to deal with wildlife trafficking. So thank you so much for that.
Hello, everyone. Yes, thank you so much, Linda. That was an amazing presentation. It's always interesting for me to hear about the new and creative ways that we might be able to use some of the existing conventions and agreements that are in place to address problems in ways that they might not have been addressed before. So thank you very much for joining us, and it was a great start to our second day of the conference. Damon, at this point in time, could you please turn over the controls to Honor Humphrey? Our fourth panel deals with legal and ethical issues related to trophy hunting, and our first presenter is Professor Honor Humphrey, who is an environmental law scholar. Honor obtained a Bachelor of Science degree from the University of Florida, Juris Doctor from the University of Mississippi School of Law, and an LLM in Environmental and Land Use Law from the University of Florida. Professor Humphrey currently teaches environmental science and environmental law and policy at the American Public University System. Honor, could you turn on your microphone? We can test your audio, please.
Yes, I think everything's working.
Excellent, looks good. So just a quick reminder to all of our panelists, we do have to stay on the schedule today. So at about 15 minutes, I may have to jump back in and just let you know that we're close to time.
I think I'm right at a tight 15 minutes, so should we all work out?
Perfect, thank you so much.
Yes, and thank you, Erin. And as everyone has mentioned, thank you to everyone who's continued to host this conference and put it on, because it's been great so far. So my presentation today will discuss the possibilities of granting legal personhood to animals as a means to stop trophy hunting. So in order to provide a quick overview of this very expansive issue, I have broken my presentation down into a few key sections. First, it's important to provide definitions of the key legal terms and principles. Then I'll move on to ethical issues surrounding trophy hunting and look at existing legal rights for animals and the environment. And then I will move on to the ethical issues surrounding trophy hunting. And then the core of this presentation comes together by looking at how this legal personhood would apply in a trophy hunting scenario and applying these suggestions to case studies. So the types of hunting. Trophy hunting is the practice of killing animals as a means to earn a trophy of the kill, including hides, tusks, or other body parts, without the primary purpose of using the animal for sustenance. Canned hunting is trophy hunting that occurs in closures where animals have been purpose-bred to be killed or hunted for trophies. And this is in contrast to poaching, where hunters kill animals without a license or approval from the landowner. So where is trophy hunting most prevalent? Trophy hunting is most commonly a tourism-based activity, with trophy hunters traveling to particular regions and countries to hunt specific animals. The countries that account for the largest sources of imported animal trophies in the United States, and the countries generally regarded as the most popular destinations to trophy hunt throughout the world, are Canada, South Africa, and Zimbabwe. What animals are most hunted? Specific animals that are hunted for trophies are often referred to as the Africa Big Five, and that includes elephants, lions, leopards, rhinos, and buffalo. And in Canada, the most targeted animals are mountain lions, mountain caribou, lynx, and elk. So what is a legal person? What is legal personhood? In the law, a legal person is defined as an entity, as a firm, that is not a natural single person as a human being, authorized by law with duties and rights, recognized as a legal authority, having distinct legal identity, or a legal personality. It is established in existing law and international law principles that the term person is not confined to just human beings. Corporations are separate legal entities that can be sued and can enter into contracts, among other rights typically reserved for humans. So simply outlined, the rights of a legal person include the right to sue, the ability to be sued by other parties, the ability to be a party to contracts, and the right to possess property. So moving on from definitions, let's look at some of the ethical issues that this presentation uncovers. It is assumed that there is an inverse relationship between human and animal rights. When rights are given to animals, the rights of humans to perform certain actions against animals are taken away. For example, if a person lives in a country where there is an existing right to hunt animals, a human's right to hunt animals will be taken away if animals are given the right to live without human interference. But rights for animals and humans do not have to be viewed as coming from a single finite supply of rights. If more rights are given to animals, they have not necessarily been taken away from humans on a hypothetical sliding scale of rights. Legally and philosophically, it is fair to say that it is the status quo that humans have a right to control and kill animals. However, if the status quo is challenged, it is easier to assess animal rights from a place of not from taking away human rights, but from a place of creating a new system that has the potential to grant equal rights to all species. Ethical dilemmas exist in animal rights law because there are no right answers that have been universally accepted. Ethical issues and the support for animal rights could consume any legal discussion. However, the goal of this presentation is to provide potential solutions to stop the practice of trophy hunting, based on the belief that humans do not have a right to kill animals purely for the purpose of obtaining physical trophies from an animal's body. The next thing that I want to cover is the existing academic and legal background on issues of legal personhood for animals and environmental objects. The seminal article, Should Trees Have Standing? Toward Legal Rights for Natural Objects, was published by Christopher Stone in 1972. It presented the idea that natural objects should have legal rights, and that these legal rights should be independent of the rights of humans. It depends on the mindset of the reader whether this premise is seen as controversial, outlandish, or well overdue in our current legal framework. The concept of legal personhood for animals, or any natural object, can be seen as not granting new rights to animals, but removing the reliance on humans to exercise these existing rights. Designating animals as legal persons would allow legal rights to be granted to the animals themselves, rather than to humans on behalf of animals. In the American legal system, the environment itself does not have standing. An interested or affected party must satisfy standing requirements in order to sue on behalf of the environment. Not only did Sierra Club v. Morton establish standing requirements in U.S. law, it provided an important insight in Justice William Douglas's dissent, which presented the idea of granting legal personhood to environmental objects. Other examples of a growing shift in the mindset of how courts view animals is the Lisbon Treaty and the EU recognition that animals are sentient beings. However, the Lisbon Treaty fails to extend more robust rights and does not grant animals legal personhood. Similarly, Alaska and Illinois have changed state divorce laws that allow courts to consider the emotional and physical well-being of an animal. Pets are still considered property, but this is an example of a shift in the public support of giving enhanced protection to animals and understanding that animals have rights beyond being owned by humans. Now, let's look at some cases where courts have tried to answer the question of whether animals are legal persons. Tilikum v. SeaWorld was a lawsuit filed by PETA on behalf of numerous orcas, including the infamous killer whale Tilikum, that were owned and held in captivity by SeaWorld. The case raised the question of the constitutional standing of whales. PETA attempted to use the 13th Amendment from the U.S. Constitution, which prohibits involuntary servitude or slavery, to claim that SeaWorld was violating the law. This idea was rejected by the court because slavery and involuntary servitude are human activities and can only be applied to persons and not non-persons such as orcas. Here's another example where courts ultimately found that animals are not legal persons. Stephen Wise and the Non-Human Rights Project filed 3 cases on behalf of privately owned chimpanzees. Using the writ of habeas corpus, the NHRP wanted to have the chimpanzees released from captivity. The writ of habeas corpus can be invoked if a person is detained unlawfully, but can only be applied to legal persons. NHRP asked the court to enlarge the common law definition of person in order to afford legal rights to an animal, but the Supreme Court of New York denied this request. The court held that the incapability for chimpanzees to bear any legal responsibilities and societal duties renders it inappropriate to confer upon chimpanzees legal personhood. Here is a case that was a yes and then ultimately a no. In 2014, Argentina's Association of Professional Lawyers for Animal Rights filed a writ of habeas corpus to release Sandra, an orangutan, from captivity. The court's ruling was interpreted as saying that Sandra is legally not an animal, but a non-human person, and therefore is entitled to some of the same legal rights as humans. However, this interpretation was not exactly what the court ruled. Ultimately, after many rounds of appeals, an appellate court reversed the ruling that Sandra was a non-human person. In late 2019, Sandra was moved to the Center for Great Apes in Central Florida, and seeing Sandra's story on the news is actually what inspired the idea for this paper and inspired my exploration of how legal personhood for animals could be used in different contexts. Finally, here's a case that illustrates an international court's view that animals can, in fact, be legal persons. Again, Argentina's Association of Professional Lawyers for Animal Rights filed a writ of habeas corpus to release Cecilia, a chimpanzee, from captivity. In 2016, Judge Maria Alejandro Mauricio ruled that Cecilia is a non-human legal person with inherent rights and can be transferred from a zoo to a sanctuary. This was a court's recognition that animals are not just things and that animals can be granted legal personhood and given rights. With an understanding of what protections and rights that legal personhood can grant animals, we can finally assess the crux of this presentation. My proposal operates under the assumption that legal personhood should be granted to animals for the specific purpose of dismantling the trophy hunting industry. The application of legal personhood could be applied in 2 ways. Either the entire species of the most threatened animals would be universally granted legal personhood, for example, tigers or African lions, or classes of more narrowly focused animals would be granted legal personhood by area. For example, all mountain gorillas that live in Volcanoes National Park in Rwanda. If entire species of animals or a class of animals are given legal personhood, the class of animals now has the right to sue. This new class of animals could file an injunction against governments that issue hunting permits as well as the hunters themselves. Injunctions are commonly used to protect animals already, but in this scenario, the plaintiff would be the animal. Particularly for animal rights cases, it is important to make it easier for standing to be established proactively to prevent possible harm, and in the case of trophy hunting, prevent imminent death. When the risk to animals is quite likely literally life or death, this would easily satisfy even the most stringent standing requirements. This scenario can only occur, though, if animals are given legal personhood and therefore standing in courts. Before I move on to my next suggestion of how legal personhood rights could be applied in trophy hunting context, I think it's important to give some background on a unique example. There is an oak tree in Athens, Georgia, in the US, that is known as the tree that owns itself. Although not ratified by law, in the 1820s, Colonel William Henry Jackson deeded the rights of this tree to the tree itself. The tree was given ownership of itself and all land within 8 feet of the base of the tree. This type of legal personhood that has been respected through the city is through a form of non-binding customary law. But the idea behind deeding the tree to itself is the idea that no one could cut down the tree unless the tree itself granted approval. So what if this idea was applied to animals? A legal person has the ability to buy, sell, and own land. This right is related to the ability for a legal person to enter into legally binding contracts. Trophy hunting, unlike poaching, occurs through an agreement with the landowner of either a private landowner or the government and the hunter. These two key elements of trophy hunting and legal personhood can be combined in a novel solution. If a class of animals within a national park or designated protected area of habitat was given legal ownership to the land, any actions that take place on that land would have to be in the best interest of the animals. Similar to the tree that owns itself, no one could hunt on the land owned by the protected class of animals unless the animals approved. Just as a corporation can live on beyond the natural life of its owners, the ownership of the land would live beyond the life of a single generation of animals and would be owned in perpetuity by the class of animals. So the application of these ideas can be quite involved, especially just hearing it and looking at slides compared to reading. So here are two simplified examples of what legal personhood for animals would look like in countries where trophy hunting is most popular. Lion conservation has been shown to be successful in both Zimbabwe and South Africa when communities and landowners manage collaborative conservancy. However, if lions were granted legal personhood in these countries, the lion themselves would be the owners of the conservancy, enhancing their legal rights. Here's an example of how offenders could be punished in a world where animals have legal personhood. If the Canadian lynx was uniformly granted personhood and granted the rights to live without being killed, this could effectively end the legal practice of trophy hunting in this specific species. But what happens if an animal's rights is violated? In this scenario, legal damages could be assessed against the offender, and illegal hunting would no longer be a violation of a statute, but a violation of the individual animal's right to live. So in summary, I just want to synthesize the key points I covered in my presentation. Currently, animals are not universally given status as legal persons. Case law has shown there's a trend towards giving animals more rights and recognizing animals as beings that are entitled to rights. Individual animals have been granted legal personhood on a case-by-case basis. Legal personhood could be used as a tool to stop trophy hunting. And extending unique rights to animals, such as the right to sue and the ability to own property, would create a new legal framework for animals to defend their right to live. So, thank you for the opportunity to present my article, and now I'll turn it back over to Erin.
Thank you so much, Honor. That was a really interesting presentation. And I think it connects nicely to some of the other presentations we heard yesterday. I'm thinking of Paul Boudreau's presentation and the presentation by Sana Ramdas. Again, where The terms we use to refer to wildlife have important legal consequences. And here, if we think of animals in a different way and use different terms to in this case, to define their rights, perhaps we can have a positive impact on their conservation in the long run. As we did yesterday, we're going to save all of the questions until the end of the panel. So attendees, if you have a question, please go ahead and type it in the question section or the chat section, and just make sure that you indicate that it's a question for Honor, and then we will answer those questions at the end of the panel. Thanks again, Honor. That was a great start to the panel. At this point, Damon, if you could please turn it over to Dr. Jan Priesner-Levine. Dr. Priesner-Levine is a senior research fellow at the Max Planck Foundation for International Peace and the Rule of Law. He works on sub-Saharan projects of the foundation. Before joining the foundation, he worked as a lecturer at St. Augustine University in Tanzania. And he is going to talk to us about the legality of tiger farming, trophy hunting, and can hunting under international law.
Thank you very much, Erin. Does everybody hear me?
We can hear you, we can't see you yet. So you may want to turn on your video if you plan on using video.
All right, I'll do that right now.
On GoToWebinar, there it is, excellent.
Great.
All right, we can hear you, and you may begin whenever you're ready. Thanks so much for being here.
Yeah, thank you. It's a privilege for me to be here. Can everybody see the screen?
Yes.
Okay, great. So thank you again for being here. So my presentation is about the legality of tiger farming, trophy hunting, and can hunting under international law. Here on the picture, you can see a very famous lion, Cecil the lion. I took this picture in Zimbabwe in 2013, and I didn't know at the time, 2 years later, well, I would never get the chance again to see this beautiful lion. At the time, he had just been expelled from his pride, and he was roaming with another lion in Huanqui National Park. And a few months later, he found another pride, and unfortunately, he was killed. What is interesting about this case, of course, is the outcry which followed, and which shows, because it was not only an outcry from animal activists or animal lovers, it was an outcry from the general public. And recently in France, which is the country where I come from, as you can maybe pick up from my very, very light accent, we had the same problems where a couple of supermarket owners went trophy hunting somewhere in Africa, came back, exposed their pictures with their queries, you know, the usual, and they were subjected to immense backlash from French people who are not renowned to be the most, you know, animal rights people. And I say that, you know, because I come from there, and yet you could see that even there, it was a huge backlash, which suggests that maybe we need to get into the ethics of this debate. All right, so I think at the source, we have to remind that, unfortunately, wild fauna is still considered as natural, is qualified as natural resources under international law, which means that the principle of permanent sovereignty applies, which means that it is a matter at the end of the day of state sovereignty. Of course, there are some limits, the principle of prevention, but as I basically submitted in my PhD, I don't think that this principle can apply in practice to biodiversity loss or, you know, trophy hunting in this context. There is no international instrument which regulates directly trophy hunting, tiger farming, or can hunting. Only CITES regulates the international trade of trophy hunted endangered species. Potentially the CMS, the Convention of Migratory Species, could play a role because its Appendix 1 prevents any form of taking. However, the synergy between CMS and CITES is such that it is very unlikely to happen, and the cheetah is an exception, is a good example of that. And recently also the lion who is in Appendix 2 of the convention was supposed to go in Appendix 1, and many countries resisted it because, of course, it is a trophy hunted species under CITES and in many African countries. I will pass on the definitions because Professor Humphrey did that already very well. I will also spare you the CITES system in a nutshell because I think you are all familiar with it, with Appendix 1 species under threat of extinction needs to be regulated under export and import permits after non-determined findings from scientific authorities, and Appendix 2 species with only an export permit. So let's go directly to the heart of it and dealing with trophies. So trophies qualify as personal and household assets, which is an exception under CITES Article 7.3. However, so normally the normal regime that I have described very briefly would not apply to personal or household effects, except that for trophies, it says in Article 7.3 that if Appendix 1 species acquired by the owner outside his state of usual residence and are being imported in that state, basically this exemption doesn't apply. So basically it would be an exception to the exception. And Resolution Conference 2.11 actually confirms the fact that normally for trophy hunted species of Appendix 1, an import and export permits are needed just like for the normal regime. However, and we'll come back on that later on, there are some exceptions for a few species, probably the most charismatic species, where which are subjected to some quotas. I'll come back to that later. For Appendix 2 species, it's actually much more complicated than what appears. It's much more convoluted, but basically, and it's really a shortcut, and I apologize for that, but Article 7.3 says that Appendix 2, so you have to have a removal from the wild, from a state outside of the usual residence of the trophy hunter, and they have to be imported in that state. It's much more complicated actually when you really analyze it, because you also have to read it in conjunction with Resolution Conference 13.7, but it's basically to give you like the basis. As I said, some Appendix 1 trophy hunted species are subjected to hunting quotas in specific countries. This is based on the fact that some countries, for example, think that their population is rich enough to sustain some limited amount of sustainable amount of offtakes. So this is the case, for example, in Botswana for the elephant, or Zimbabwe. Same thing goes for leopard, the marco, which is a mountain goat from the Himalayas, and the black rhino. So they have their own specific regime, and basically each country is allocated some quotas, and they cannot go over their quotas. But in practice, the quotas is not really monitored. The quotas are set on very, very outdated scientific studies, which was actually the subject of an article from Ari Troborst about leopard trophy hunting. What is CITES stance on trophy hunting? So basically, in all resolutions, they always remind the audience that well-managed and sustainable trophy hunting is consistent with and contributes to species conservation, as it provides both livelihood opportunities for rural communities and incentives for habitat conservation, and generates benefits which can be invested for conservation purposes. So that's the theory. I mean, I would have many objections to that, but that's the stance. This is also supported by IUCN. And then Resolution Conference 17.9 makes several recommendations to states to regulate trophy hunting so that it remains sustainable. I have to underline there that unlisted species, and this is the problem with this methodology of listing species, do not enjoy any protection. And this is the case, for example, of the sable antelope, which is, according to me, the most beautiful antelope in Africa, on par level maybe with the greater kudu. But let me give you a little bit of background on this antelope. Already, even in protected areas, it's extremely difficult to find sable antelopes because they are basically outcompeted by other herbivores, be it zebra or wildebeest, or all the others. There's a really good study about that by Richard Desperate Estes on the sable antelope. So already they are uncommon even in protected areas, and yet they are not protected internationally, which means that basically there's no really limits, on their trophy hunting except at the national level. And so the trophy hunting, which is added already to a difficult conservation status, make it even worse for this species. And I would also add to it its close relative, the Rowan antelope, which is almost as beautiful. And so this, of course, is really problematic. I mean, if you go to protected areas, even the most famous one, it will be really a challenge for you to find a sable antelope. You can find them, if you're lucky, in Kruger. The best place is Hwanki, or maybe Chobe National Park in Botswana, maybe Ruaha in the Tanzania. But even there, good luck to find a sable antelope in Ruaha. Objection to CITES on a purely conservation standpoint, despite some success stories, and the campfire program in Zimbabwe comes to mind, trophy hunting is rarely well managed. And I could give you my personal experience from Tanzania, because when I worked there, and I used to live 2 hours away from the Serengeti National Park. Yeah, I felt very privileged for that. Although my PhD director was a bit concerned I would spend too much time in the Serengeti rather than studying on my PhD, but that's another story. And close to the Serengeti National Park, there's a controlled area called Loliondo, which was leased to some royal families in the Emirates. And there was some abuse on how many species were trophy hunted there without any kind of control. Maasai people being chased from their lands, cheetah cubs being confiscated from their mother to be taken to the Emirates for the pet trade, and so on and so on. So, and also on this, because it's not properly monitored, and there was also a lot of corruption going on. As I said before, there are managed through quotas based on outdated scientific methodology, and then I will direct you to the study of Arthur Borst on leopard trophy hunting, where he explains that very well. Fees paid to trophy hunters go through many middlemen before being reinvested in conservation. I'm not saying it's a myth, but it's not as true as they make it to be. I mean, most of the fees goes, of course, to the safari company. It goes without saying, and then maybe to the state authorities before going back to conservation, if at all. According to some studies, less than 3% of the fees reach local communities. I mean, there are also examples to the contrary, but this is a general trend. Trophy hunters target reproductive elements of a given population. Obviously, what they're interested in is to hang them on the wall. So, of course, the species that it will target is the one with the biggest attributes, like lion manes, like sable antelope horns, or greater kudu horns, like Ernest Hemingway. So, of course, these animals bear the burden of reproduction in their groups. That's true for lions. Actually, Cecil the lion, even though he was old, was still a reproductive male. And it's true for most of the herbivores which are targeted by trophy hunters, be it sable, gemsbok, and so on and so on. If added to other causes of biodiversity loss that can threaten a given wildlife population, it is used for wildlife laundering. There's been some links there. And the Lem Tong Tai case from the Supreme Court of Appeals of South Africa comes to mind, where Vietnamese basically criminals, part of criminal syndicate, basically faked their permits. It was search as permits awarded by the South African authorities to basically poach rhino horns for the Asian market. And last but not least, there are some studies among which the IUCN ethics specialist group saying that actually trophy hunting is not sustainable. Of course, this is debatable, but I think it needs to be said. Going to can hunting, so I would say can hunting is a form of trophy hunting. It's not addressed directly by Public International or indirectly through CITES. There's an annotation for parts or derivatives of captive bred South African lions, which are traded for commercial purposes. But I would submit that it would not apply to captive bred lion trophies, in the sense that the purpose is non-commercial there. I mean, trophy hunters are not willing to sell the trophies. Most of the time it's to put in their house. So I think that the usual trophy regime under CITES would then apply, although it's not so simple, because, and this is where we would need actually a legal definition for can hunting, because if you go to the breeders who are in this industry, they said it's really important to differentiate between canned hunting, lion can hunting, and lion ranch hunting. They made this distinction after, of course, the outcry generated by the famous movie Blood Lions, and so they want to make it a bit more ethical. I think that the distinction is absolutely trivial. According to them, they say that can hunting is really like the animal is within an enclosure, and the trophy hunter comes, shoot it, it cannot escape. In ranched hunting, basically what happens is that the lion is also captive bred, but then it is released in the wild, and then or into some kind of free area, and then the trophy hunters kill it. Why do I think that this is a very trivial distinction? Obviously, you understand that if a lion has been captive bred, he lost his fear of humans, and he doesn't behave like a natural lion would do, which is to run away from a human being. And actually, when they see the trophy hunters coming for them, they don't run away. So where's the real freedom in there? I don't know. So I think this is very, very trivial distinction, but it can have some consequences in the way CITES permits are being applied. Unfortunately, I can't go in depth into this issue, but I'm writing an article about this. IUCN members have called for legislation to ban can hunting, and even hunters have said that can shooting is an ethically repugnant embarrassment. IUCN recommendation 3093 positioned all forms of can hunting on ethical grounds, and I will come back on that later because it's actually very, very interesting. Going to tiger farming, so everything that all the information I gathered actually from CITES documents. There's very limited conservation value of tiger farming, if at all. First of all, because tigers cannot be released in the wild. This is an absolute fallacy, which has been proven time and time again by biologists. Releasing a predator in the wild is extremely difficult. Recently, a pack of wild dogs, African wild dogs, were released in the Tsavo. All of them died because, first of all, they don't know how to hunt. They haven't learned how to hunt in a wild environment. They don't know how to recognize threats and potential predators. I don't know if some of you are familiar with Big Cat Diaries presented by Simon King. And he tried to release some cheetahs in the wild, and I think one or two of them got killed by lions because they could not recognize the threat. So for predators, it's extremely difficult, if not unrealistic, to try to release them in the wild. And I could give you many, many examples where it failed. So the genes, the genes get mingled also when they are captive. For example, it's very controversial to mix the genes of a Siberian tiger with that of a Bengal tiger or that with an Indo-Chinese tiger, because then the gene pool will be affected. And also because of the overpopulation of captive tigers, there's twice or thrice the numbers of captive tigers than there are in the wild, and so it would be realistic to even think of releasing in the wild. So this is a conservation argument put forward by Chinese breeders, and to say that, yeah, it supports conservation, but in reality, they will never, ever be released. It also fuels demand for tiger products, and there is no relief on wild tiger populations, contrary to what is commonly assessed. The rationale behind tiger farming is that it supports conservation because if they are being raised and then maybe bred for commercial purposes, maybe people will stop poaching tigers in the wild. That is not true, because there have been many studies showing that even though tigers products would be available on the market, people would still prefer to go for wild tigers because of supposedly enhanced properties. So also there was a link which was acknowledged by CITES that some tiger farms were linked with wildlife laundering, and this is what happened with the Temple of Tigers in Thailand, where there was evidence that it was linked with illegal trade of tiger parts. And another major problem is that then other Asian big cat species suffer the brunt of it, because as tiger populations dwindle, poachers and illegal traffickers then go on snow leopards, clouded leopards, and even lions. And what is interesting is that they even go for the products of the canned lion industry in South Africa and then market it as tiger products. With lions, it's especially tricky because lion bones look very similar to tiger bones, and it's very difficult to distinguish them unless you're an expert. For tiger farming to contribute to conservation, according to a study from Stetson, farm products must provide a substitute for wild products. Wildlife farms do not have to rely on wild populations for restocking. Legalized farming is more cost efficient than illegal poaching, and the demand for wildlife farms does not increase, and laundering for illegal product is prohibited. I can tell you that at least one or two of these conditions will never be met. First of all, legalized farming is more cost efficient than illegal poaching. I mean, forget it. I mean, although illegal poaching can be more expensive than we think, because then you have to transport the parts of the tiger to another country, so this might involve a lot of cost. Farming of tigers is extremely expensive, as you have to provide for food, facilities, and so on and so on. So this will never be, this cannot be realistic. Wildlife farms do not rely on wild population. Well, there's some doubt on that. Farm products must provide a substitute for wild products. Well, according to the studies, this doesn't happen. People will still prefer to go for wild products. Tiger farming on the CITES. So tigers in Appendix 1, so basically there's no trade normally allowed for tigers apart unless you have the permits. Decision 14.69 says that tigers should not be bred for trade in their parts or derivatives. This has been a very controversial decision, especially for which was contested by Chinese representative. Resolution Conference Point 5, which is about tiger trade and other big cat trade, is also relevant there. Makes recommendation on how to countries on who have tiger breeding facilities and how to manage them, as appropriate as possible. And then I put you like a decision 17/228, which also makes recommendations to parties who have big cat captive facilities. So this is a major problem. And at the heart of it is that, first of all, I think that the status of natural resources for wild animals negates their ecological and intrinsic worth, and more importantly, their sentience. So I think there has to be a change there. It also reflective of the utilitarian philosophy which underlies all conservation policies with a very holistic anthropocentric perspective. And this also, I think, needs to change. And as Professor Humphrey said very well in her presentation, I think that the interests of the animals have to be taken into account. The conservation narrative is too much fraught with anthropocentric perspective to have an effect. And if we look at the trends, despite all the treaties which all have a utilitarian perspective, yet all the population of wildlife is dwindling, and we are definitely falling behind. So I think it is time for a change of perspective, and that maybe granting rights to animals would be the solution. And I think there is a need for ethics into the debate, and I will quote Wagmans, who says that the law cannot exist outside of ethics, and the philosophical considerations of our treatment of animals logically center on the ethics of our relationship with them. And it's really funny because in the way ethics are being dealt with in the international organizations, if you compare trophy hunting and can hunting, so the objective is the same as trophy, rationale is the same, conservation. Now, CITES and IUCN say, okay, we acknowledge that trophy hunting contributes to conservation, but refuse to go into the ethical debate. And actually, it's interesting to note that the IUCN refused to endorse their own IUCN ethical committee when they concluded that trophy hunting was unsustainable. They said it was just a view of mind and opinion, which was issued in the context of a more general debate, and they refused to endorse it. Whereas, as we've seen later on, they say, can hunting has no conservation value, but they based it on ethical arguments. And there's an inconsistency here. Of course, I understand that trophy hunting is a bit less unethical than can hunting in the sense that at least the animal is free. But this is not my point. My point is that ethics are raised basically when it suits them, and there's no consistency in when they raised ethics. There are many.
Jan,
Yes.
I'm so sorry to interrupt. I did want to let you know that you're almost at time, so if you could conclude in the next minute, that'd be great.
Yes, so there are many ethical and physical grounds to consider. I will just quote Alexander Pope, said, if we kill an animal for our provision, let us do it with the methods of compassion and without tormenting it, and so on. There are many, I think you are all familiar with them. There's a shift of paradigm with the EC sales product case and many interesting European court cases, and Judge Pinto Albuquerque acknowledges that there's this shift of paradigm, and you can see it in national laws as well, so not everything is doom and gloom. And I think that last but not least, that zoology and other sciences needed, because ethics are, at the end of the day, are very subjective, And we need to ground this on facts, and it's zoology, ethology, which basically gives us the facts. There are many studies out there, for example, on hyenas, showing that they have, very high cognitive ability. There are some studies there, and I'm frustrated I cannot go into this with you, even cephalopods. And as science sheds light on the cognitive abilities of animals, the more it will grant the ethical debate on the fact that no, we cannot just consider animals as just commodities. So I will also join Professor Humphrey in her conclusions. Thank you very much.
Thank you so much. That was really interesting. I think we all hear a fair amount, I'd say, about trophy hunting, but I for one don't know much about the distinctions, or maybe the lack thereof, between trophy hunting and can hunting. And then I thought the discussion of tiger farming was really interesting as well. So thank you for sharing all of that information with us. I neglected to note when I introduced you that you're also a wildlife photographer, and I believe all of the photos on your slides are ones you've taken, right?
Yes, that's right. Yeah.
They were beautiful, and please feel free, if you're comfortable, to share your wildlife photography link with everyone in the comments area so that perhaps they can check that out later if they're looking for a nice distraction while they're stuck indoors. But thanks again for a great presentation. Damon, at this point in time, we are going to turn it over to Professor Mayana Dellinger. Professor Dellinger is undergoing promotion to full professor of law at the University of South Dakota School of Law. She teaches contract, sales, public international law, and human rights. Mayana researches and writes on the intersection between international environmental law, wildlife law, and business law and policy. And interestingly, she is also a federally licensed wildlife rehabilitator. She will be talking about trophy hunting, public policy, and the precautionary principle of law. Mayana, can you turn on your video, please?
Yes, I'm working on that right now.
Excellent.
So you could hear me at least?
Yes, we can hear you, and we can see your desktop, your screen.
That's awesome. I have IT here with me. I think maybe you can see me right now.
Yes,
Good morning.
wonderful. Thank you so much for being here.
Oh, absolutely. Same outfit as Jan. Apologies for that, but that's how it's going to work out. And let me just go to full screen here in the background. And while I'm doing that, a happy note that I did get the promotion to full professor of law just the other day. So
wonderful. Congratulations.
Thank you so much. All right, so I'll be talking about the things that you just mentioned today. I'll define what trophy hunting is, and I will then, sorry about that, talk a little bit about the extent of trophy hunting, arguments for and against, and then I'll go into some more legal and a little bit of philosophical discussions about the issue. So first of all, can you still see me, by the way? Because it's looking a little different on my screen, but I believe you can still see me, right?
Yes, we can still see you. We see the video of you and your slides below.
Perfect. All right. So people might know in this forum what trophy hunting is, but I thought still I would just mention it briefly. It's considered a sport, which I'll question later on, and you could guess why already from what you've heard already. So trophy hunting is then the practice of, for different legal reasons, not bringing, or practical reasons, maybe not bringing home the whole animal, but rather just horns or a head stuffed on a wall, as you've seen different places, or the infamous kill shots that you'll see some of shortly. So who is it that undertakes this sport, as they call it? So it typically is wealthy individuals from the global north that pay locals, such as, for instance, guides or landowners, and very often in the global south, in particular in Africa, to assist with these planned hunts of often rare, as I call them, and sometimes even threatened species. Even in rare cases, endangered species, you know, the big black rhino that the TV personality killed some years ago to experience a rhino, as he called it, because he knew it was controversial to say to kill it. So these species, such as lions in particular and other things as I've just mentioned, for a fee. And for instance, the ones that are really popular are the African big five species: buffaloes, elephants, leopards, lions, or rhinos. In North America too, there's people hunting sometimes for polar bears, bighorn sheep in the contiguous 48 states, and mountain lions are also popular targets. So here's the episode that everyone, I think, heard about. Walter Palmer, the infamous Minnesota dentist who killed Stetson the lion a few years after Jan had just taken a much better picture of Cecil. Here he is a couple of years later, dead. This is how big the lions are, and here's a romantic picture. As noted, people that undertake this practice call it a sport. I'm saying that tongue in cheek. It seems like, I don't know, maybe it isn't. It's not only men, it is typically men that are the hunters, but there are examples of females too undertaking this kind of hunt. Even children are taught how to do this. And here's another horrible example. This is obviously a dead cheetah. And to most of us, this is probably pretty horrible. And that's the standpoint I'll take, that it's, I'm personally advocating against trophy hunting, even though in the articles I've written about this, I do recognize that there's also arguments for trophy hunting. But that's, again, not the advocate's point of view that I take. So the extent of this is that American hunters, for instance, have killed more than 5,000 African lions and imported parts of them as trophies over the past 10 years. And between 2005 and 2014 alone, more than 1.2 million trophies of more than 1,200 different kinds of animals were imported into the United States. So a lot of animals that we believe, some of us believe, should be left alive to breed and contribute to the species. So the arguments for the trophy hunting is that, as we heard, it brings in revenue. So in South Africa, that has the largest trophy hunting industry in Africa, it brings in more than $100 million a year. The arguments are it creates jobs, it adds to the awareness of conservation issue. That argument is one that we'll typically see here in the United States. Especially in those parts of the nation in which I work, which is out in the Midwest, that, you know, it's totally focused on how much this helps the species by creating awareness and bringing money to the local areas and so forth. Trophy hunters will also say it generates more income per client than general tourism, and it creates an economic justification for wildlife as a land use area, because they argue, that trophy hunters do, that if there's no trophy hunting, then these areas in which trophy hunting and other types of hunting is currently going on, that then might be converted into livestock or agricultural use. And all of this, I'll talk about this later, are arguments, and they're not firmly established. So all of this is questionable. They'll also argue that trophy hunting creates buffer areas between urban and wilderness areas, where otherwise they argue, you know, this land would just be converted to urban area. And overall, in general, they will argue that if there's no trophy hunting, the wildlife populations will decline. And again, as others have talked about, and as I point out in my research, there is simply no objective unanimous evidence on the connection between trophy hunting bans and such declines. Or in other words, there's no established science or economic firmness that trophy hunting actually does financially or otherwise contribute to the local economies. And not only that, but I would also point out there's a logic fallacy here, in my opinion, that it flies in the face of logic, in my opinion, and that of many others, to say that you could save these animals by shooting them. It just doesn't make any common sense at all. The argument is typical, or has been, that, well, you know, it's only these older non-breeding males that are killed. But that too is just not true, as we saw, for instance, with Cecil the lion, who was still a breeding animal at the time. He was killed, and granted, that arguably was a mistake, said the dentist, but nonetheless, this breeding animal was targeted. So again, I and many others just don't think it makes sense to say you could save these species by killing some of their most the largest and breeding members of them. So there's many arguments against this also. These animals that are hunted, the big five and others, are typically rare, as I call them in my articles, to avoid going into the legal differentiation between whether they're endangered or threatened. But regardless, everyone can agree that most of these animals that are targeted are, at least in common lay language, rare. Such as lions, and these are just declining. And so again, when these hunters kill typically the largest, most prominent or strongest alpha males or alpha females, but typically the largest alpha males, this actually drives evolution from a human point of view. So human beings drive evolution. In other words, evolution can go fast. So we're seeing already that the remaining animals, future generations of these animals, are smaller. For instance, in the case of North American bighorn sheep, they have smaller horns. And why is that? Well, because evolution quickly finds out that if you're a big animal with big horns, you're going to get shot, typically. So we're already seeing evolution, and that goes not only for trophy hunted species, that also goes for instance, for fish. So halibut is a lot smaller right now than they used to be, because there's fishing restrictions of, you can't catch fish that are, too big or whatever. So nature quickly then evolves into realizing, okay, well, we're just going to make smaller specimens then. So it's scary, I think, to know that we as human beings are driving evolution that fast. Conservatives are also more common in areas where ecotourism and not trophy hunting is prevalent. So it would be better, many of us think, to have conservancies and not trophy hunting animals or areas or canned hunting areas. And so also, whilst we heard already some researchers have claimed that trophy hunting is a huge industry and brings a lot of money to, for instance, Africa, then a lot of this research is based on unpublished or unresearched tallies by hunters associations. So for instance, some of you may be familiar with a very large Safari Club International that does a lot of this so-called research, or funds a lot of its own research. And so a lot of the quote research that's on the market we need to look into, obviously, who produced that research, because it can obviously be tainted by whoever paid for it. And certainly that association puts out numbers that are often questionable at best. So again, it's important to be critical towards the so-called findings that are produced in this respect. Further arguments are that for the 11 countries that where big game hunting is the most widely practiced, hunting preserves take up about 15% of the national territory, but it account for less than 1% of the respective countries' GDP. So again, the notion that it brings in a lot of money and it's so important from an economical point of view is questionable. In contrast, earnings from tourism overall are up to 6 times the amount that's accrued from trophy hunting. And so again, conservancy or regular photo hunting may be better from a zoological or a zoo-centric point of view, and from an ethical and futuristic point of view as well. Trophy hunting can also create increased demand for trophies that may lead to poaching. So we saw that in the example of ivory when it was first banned, and then they tried to release or to legalize some trading in it for a certain amount of time. And then the thinking was that you can't just segment or silo those different developments, that there's a spillover effect where, as we heard already, if there's a demand for something and supply of something, that may increase the demand from that product, including from trophy hunting or poaching, which are 2 different things, but still, from an overall point of view, the demand for certain products may increase from legalizing or having trophy hunting into areas such as poaching and other illegal activities. And then, as we heard already too, and I think this is really thought-provoking, very little of the revenue, so as little as 3% of that revenue that comes from trophy hunting may actually go to the local communities where the hunting occurs. So again, the typical argument is how much money it brings to the local communities, and that is just not a fact at all. There's also significant corruption concerns in this regard. So all of this is talking about things from the traditional monetary usage point of view, and values, how much value is brought to human beings basically, and how much values these animals have to us. What I think fails from the discussion is some of the things we're now starting to hear about is what about the values of just the animals themselves to us, just knowing that they exist. Or what about the animals or the values of the animals to the animals themselves? We often don't discuss this in the rhetoric. So I think just starting from looking at the existence value, as researchers have called it, there's a value of just knowing that the animals are around. So studies were done where people got a fake amount of money, and they were asked to place it on whether they would choose to, say, shoot an elephant right now to earn a certain amount of money on it, or whether they were willing to pay what was called an option price, so to keep the animal alive so it would be around for the future, and it might be quote unquote used in the future, even just from photo safaris or tourism. These studies showed that 34% of people actually would prefer to place value on the existence value, compared to 7% only for the current use value. So 34% of people would like to just see animals being around. There's value to us as human beings in knowing that species exist and that they'll do so for future generations. And this is true too for whether or not you actually yourself will go on a photo safari or whatnot. Just think about how many of us enjoy watching nature shows, right? Documentaries and things like that. So that's where this comes into effect. And further, people also place no less than 48% of an intrinsic value on the animals themselves. So in other words, 48% of people in the studies that were the foundation for this research found that wild animals don't actually have to be good for something. They don't have to have a use for a value, or use as a value for us human beings. Why? This makes sense. There's just a value in them, in and of themselves, independent of how we could actually use them, quote unquote, in one way or another. And so those are two other values that are typically not discussed in this rhetoric, but that should, because as we see, those values are significant too. And as we heard also from Jan and others already, there's also spiritual and ethical discussions in this connection that are often, I think, ignored in our very fact-based scientific, quantitative or qualitative research systems. And I won't go into that, but in many spiritual or religious traditions, values or a certain appreciation is placed in not only animals but in ecosystems and even rocks or natural products, such as what Native Americans hold those items to have. And also ethics beliefs became prevalent with the discussion of Cecil, where we heard already that a lot of people really believed that hunter and others like them have now crossed the line where trophy hunting simply isn't an ethical endeavor anymore. So those are discussions that I deliberately put at the beginning of my presentation before the law, because I think we should shift to an extent when we can the discussion into talking about some of those sort of non-hardcore hard law discussions. But shifting a little bit though, because we are in a legal conference, to the law of this, I'll skip over the CITES regulations, as we already heard about those already. It does come into play, though, seen from a North American point of view in relation to whether or not the trophy hunters, many of them come from North America, as I mentioned already, can bring back to North America, typically the United States, their trophies from the animals that they killed overseas. And typically under CITES and other law, also national law, they cannot. CITES in the United States is administered through the Endangered Species Act, just so people know that if you don't already. So in my articles, I have not looked so much at the regulatory framework as I did under a couple of other bodies of law, namely first contract law. And the reason why I became aware of this area of law that relates to the issue of trophy hunting, at least in a few contexts, is again the Cecil the Lion episode back when. So if you recall, that hunter from Minnesota had a contract with a private landowner for the landowner to help Palmer identify the lion and come onto the land and shoot a lion there for just $50,000, which is also a ridiculously low amount. So again, there goes the notion that this, trophy hunting contributes so much to the local economies, because for one, it wasn't a lot of money, hardly anything, to be honest, if you think about how little $50,000 really is in the grand scheme of things these days. And second, it didn't trickle into any needy pockets. It went to an already relatively wealthy landowner. But anyway, they had a contract for the landowner to help this hunter. So shifting to contracts law, there's a notion called void for reasons of public policy, where courts can declare that contracts are, as I said, unenforceable if it comes to litigation for reasons of public policy, where a promise or other term of a contract, the interest in its enforcement is clearly outweighed in the circumstances by a public policy against the enforcement of such terms. And that, from a historical point of view, has held to be the case with, back in the day, gambling. Now that's been legalized regulatorily and through contracts law also over time. But prostitution, still illegal in many states, but that too was actually the other way around. These things were legal and now became illegal rather, through contracts law. The opposite is the case with surrogate motherhood, that now you could enter into a deal to become, if you wish to do so, a surrogate mother for other females, and that is not violating either regulatory or contracts law anymore. Non-compete clauses, where employees were held, at least in California, to not be legally entitled under contracts law to work for competitors after they were leaving a company, have now precisely been held to be void for reasons of public policy, at least in California.
Hi, Anna.
Yep.
Hi, Anna. I hate
Yep.
to interrupt, but we're almost out of time. So if you could please wrap up your remarks in about a minute, please. Thank you.
Sure, sorry about that. So
Sorry.
yeah, no, that's all right. So I'm just basically arguing, and I'm towards the end anyway, that that contracts should and could, by courts of law, if there's any legal dispute under them, be held unenforceable, because most people modernly actually disagree or agree that trophy hunting is despicable. Even a lot of the hunters themselves believe so. As I say here, 34% of hunters believe even that trophy hunting is wrong and should be outlawed regulatorily. The difficulty is in contracts law, if the parties agree on this kind of contract, who then could call for it to be held unenforceable. But the notions are out there, and the public opinion, at least in this country, and as we saw around the world, is also shifting to go against trophy hunting. And last but not least, I want to point out the precautionary principle of law under the Rio Declaration that says that when there's a risk that there's irreversible damage to an ecosystem, or in this case species, and as is the case here, lack of full scientific certainty, then that should not be used as a reason for postponing cost-effective measures. So again, when we don't have certainty, as here, about how beneficial it is to have trophy hunting, then we should, out of precaution in favor of the species, go ahead and halt that practice to avoid or to minimize the threat to the species, precisely because we should be precautionary and conservative in our approaches to this. And here's some figures that show how few of these different animals are left.
Thank you so much.
That basically concludes that.
Excellent, thank you. I'm glad that you brought in the precautionary principle. I don't know if you were on yesterday, but we had a wonderful presentation by Mark Hampens about the precautionary principle, and so it's nice to hear about it again and in a particular context in which it's relevant. I also am interested, and I hope we have time in the questions, but I'm not sure. I'm interested to learn more about the contracts law sort of analogy that you're drawing. At this time, I would like to ask all of our speakers from this panel to turn back on your microphones and your video, and we have time for just a couple questions. And as yesterday, to the extent that we don't get to someone's question, we will try to pass those on to the speakers so that they can follow up with you after the conference. All right. So a question for Honor from Volker Mauerhofer. How would buying land through animals happen in practice, in your opinion? We can't hear you.
Yeah, sorry, it was muted by someone else other than me, but here we go. So how would animals buy land? Of course, I love the idea of a lion going to a realtor and then, you know, like putting its paw on the contract to buy land, but that obviously can't happen yet. So in my proposal, I think the land would, any like nationally owned conservations, national parks that are owned by governments, instead of them being owned by governments or the people, it would be deeded to the animals so that the animals own. So it's not that they're buying land, but are given the land as the owners instead of the people of a country or just the general federal government.
All right, thank you. This, I believe, is a question for Jan from Blaise Pascal. Blaise Pascal, if this was meant for someone else, please type in the box and let me know. But it says, I'm curious to know how the Maputo, I'm sorry if I'm mispronouncing that convention, I'm not familiar with that one, and the CBD deal with the protection of these hunted species.
Okay, so the African Convention, can you hear me? Yeah, so the African Convention basically has some provisions to allow for the sustainable use of wild animals, so it doesn't prohibit trophy hunting. I don't have the provision exactly in mind, but I can tell you that it does allow trophy hunting. As for the CBD, it's a framework convention, so I mean the only relevant articles are the in situ conservation and ex situ conservation articles. It doesn't really deal with that issue at all. It's all about sharing equally the rewards of nature, but it doesn't deal really with trophy hunting or the exploitation of animals as such. It's much more general.
Thank you. I believe Ari Trauborst has a question. Ari, would you like to unmute yourself and ask your question, please?
Sure, thanks. So this was a really interesting panel, fascinating subject matter, raising many questions, and the Q&A time is way too short to do this this topic any justice, I would say. Let's see. I just want to quickly plead with Jan Prisner-Levine for adding the Nyala to the top 3 of fantastic antelopes besides sable and kudu, which I'm fine with. That said, thanks. So about the precautionary principle, I'm wondering if on the basis of the available evidence, it could not just as well be flipped around and say, and it would be interesting to hear your reactions to this, and say on the basis of the available evidence, you could also make a credible argument that banning trophy hunting or the import of trophy hunting into countries like the US and European countries carries the risk of unintended consequences if those who warn against banning it too quickly are right, and areas that are now used for trophy hunting would then receive a different land use, where the whole ecosystem would disappear. In that case, would it not be preferable to have a situation where there is even unsustainable trophy hunting of a few target species, but within an area that supports nature with birds and vegetation and so on, instead of cropland? Yeah, so I'll just see who'd like to react to that. Thank you.
I can do that, and you're exactly right. It is a double-edged sword, precisely. And so you could keep saying, well, how should we flip it and how should we flip it? So I would say the ultimate concern is here, and everyone agrees that, even hunters, the ultimate concern is to save these species. No one in their right minds wants to drive them into extinction. And so as long as we don't have yet the full scientific certainty or economic certainty of the benefits of trophy hunting, then the overall intent of the Rio Declaration and other, more modern law is to then preserve the animals. And again, we know that it's not only old animals that don't breed that are shot, it's also breeding animals. So again, we should halt. The intent of that whole declaration was to halt anything that might degrade the species, and so that was the spirit, the letter and the spirit of that whole argument. And then, but so again, you're right, that could then be flipped around once again. So what I think we need to do is to start looking into why is there no, better studies done? Can we not find out from a more established point of view soon whether or not this actually does contribute to species preservation in the long run? Why are we still in this much doubt about it financially? So I would say more studies should be undertaken, but we should also look into more of, the ethical, spiritual, holistic arguments. I personally believe, but I know a lot of this centers around the mere values themselves and numbers. So I would advocate at bottom for more certainty in this area, so we could address these issues, better.
Thank you. Ari, did you have any follow-up questions or response?
Yeah, so yeah, just a double-edged sword is a nice expression, I believe. In this situation, it's hard to say what the most precautionary course of action is. What is the danger you're focusing on? Because you could, as I said, flip it around and say the threat here is to rush towards banning these possibilities for trophy imports with possible irreversible consequences, namely the complete loss of ecosystems that now exist. So yeah, it's perhaps nice to end with the sort of bearing in mind the neutral formulation of the precautionary approach in CITES and conventional migratory species resolutions, which focus on doing what is in the best interest of the conservation of the species on the basis of the available evidence. And theoretically, in some situations, be continuing with trophy hunting, and in other situations, be banning trophy hunting.
The only thing, if I could add something quickly to that, Aaron, and I'll be really quick, is I agree with that. So you mentioned the rush. The only counter argument I would say to that is that there is a great rush because there's just not that many of these animals left. So what if, as you say, we're finding out in 20, 30 years from now that whoops, trophy hunting really was bad for the species, and now they're gone. You know what I'm saying? So that's why we better halt it while there's some of those around. Every single species or animal, not species, but every single animal counts. So that would be the rush here, and that would be what I would see would be the argument for halting this practice. And as I advocate in my articles, I'm not saying it couldn't, I would never do it personally, but I'm saying we should halt it until the science is clear that it in fact is beneficial out of the fact that so few of these species are left. But those are the arguments, you're right.
If I may just add something as well, is that we also take the assumption that there is no alternative to trophy hunting, that if you ban it, it will lead necessarily to a catastrophe. But there are other alternatives. Trophy hunting is not the only way to preserve, to set aside land for conservation or anything. Of course, there's wildlife photography, not only with cars or anything. There are many other ways, other alternatives, also involving the communities outside of trophy hunting. So this kind of idea that if we ban trophy hunting, it will be a catastrophe, maybe not, because we can put a ban and then also provide for temporary measures, which involve alternative forms of wildlife viewing, which would also bring some money and then create some conservation incentives.
Thank you. I hate to end this discussion, but we do have to stay on time. So thank you again to all of our speakers for your wonderful presentation. Thank you to Ari for joining this discussion. On the note of wildlife photography, Jan, there are calls in the chat section for your website. If it's okay with you, I'll post that. All right, great. So everyone, I'll post that link so you have something to look at later. Thanks again to our panelists. This was an excellent discussion of these trophy hunting issues.
Thanks, Aaron, and thanks. Thanks everybody on that last panel. That was a great panel, and we're going to move right into our last panel. And as I mentioned yesterday, Will Burns initially created this conference with students in mind. He wanted to give students the opportunity to interact with wildlife law professionals, and also have the opportunity to present. So we have two students who will be presenting on this panel. And so if we could turn the controls over to Rui, please. Rui Melo Filho is a student at Universidade Federal da Bahia in Brazil. He is a researcher in public international law, and also was a semi-finalist at the 22nd annual Stetson International Environmental Moot Court Competition, and when he was named the 5th place oralist. So it's great to see you back in this capacity, and I will turn it over to you, prefacing it with I will break in if we're running short on time. Thanks.
Thank you, Professor Gardner. Okay, so yes, as he said, my name is Hui. I'll be discussing this topic here. Let me start the presentation. Okay, so I'll be discussing this topic here, which I call this continuum between consent to be bound and treaty interpretation. And before anything, I should define that by treaty interpretation, I'm talking about two methods specifically here. So the methods of subsequent agreement and subsequent practice as laid out in the Vienna Convention on the Law of Treaties. So I'm going to talk a bit about how this has been dealt with in the jurisprudence of the International Court of Justice, especially with a relatively recent judgment of the whaling in the Antarctic case. And of course, you can spot the relevance of this to international environmental law from early on, because these subsequent agreements can be usually related to so-called soft law under international environmental law. So this is the relevance, and this is why I've been drawn to this subject, is because of how this can actually impact disputes in international environmental law. So, okay, let's carry on. There are many documents related to this particular thing. I'm not going to go over all of them, of course, because there isn't time for that. I'm going to focus specifically on the judgment I mentioned. But there is, for instance, a document from the International Law Commission, the draft conclusions specifically on subsequent agreements and subsequent practice. They are very important for this matter as well. So if you are interested in it, it's a good document to start with. And yes, okay. But yes, I will focus especially on the whaling because it is an interesting precedent. It's a relatively recent and actually may or may not shape future disputes in the environmental matter in the future in the International Court of Justice. So to start, let's go to the Vienna Convention on the Law of Treaties, because as I mentioned, there are the subsequent agreements and subsequent practices, but the general rules of interpretation as laid out in that article would be obviously the ordinary meaning of words, the good faith, the context of the treaty as highlighted here, but as well, the very same article about the general rule of interpretation also mentions subsequent agreements and subsequent practice as means to interpret any given article from a treaty. So having that recognized under international law, let's carry on for the jurisprudence per se. So in the past, the court has already dealt with, let's say, resolutions, these supposedly non-binding documents on a variety of matters. So in two advisory opinions, like the certain expenses case, which is quite old, and a more recent one, the wall in the occupied Palestinian territory, the court did make use of resolutions that were approved by a majority of the parties concerned, but not all of them. And they used these resolutions to reach an understanding and interpretation of a given article of a treaty. Okay, that's what's important about these two advisory opinions for now. There are other cases as well that relate to this very same matter, and that the court did took a similar course of action. But in the Whaling the Antarctic case, the court did it a bit differently. So I'm going to introduce, for those who are not familiar with this case, what exactly it was. So Australia brought a dispute before the ICJ, claiming that Japan had violated an article from a treaty, that the article said basically that it allowed for the taking of whales under purposes of scientific research. And Japan claimed to be under fulfillment of that article, and Australia claimed that it was actually acting in guise, as the court said on the judgment. But the thing is, and if we take a look here at the article from the convention, which is the International Convention on the Regulation of Whaling, it says that any contracting government may actually grant a permit authorizing the taking of whales for purposes of scientific research. Australia relied on a number of resolutions to define what scientific research was. These resolutions were from the international, I forgot the name of the governing body of the convention, but it relied on those resolutions to explain what scientific research was. And the court, however, took a different path. It said that those resolutions could not be adopted without it having been approved by every single party in the treaty. Otherwise, only if it had been approved by all the parties to that treaty, then it could actually be considered a subsequent practice or a subsequent agreement within the meaning of the VCLT. And that is actually quite a confusing passage in regards to jurisprudence of the court, because it raises a few questions, which to illustrate, I decided to focus on these two main questions here. So first, why does the court need consent to interpret a treaty? Provided that it has jurisdiction, why would it need to have an extra sort of consent to interpret a treaty in a given manner? And the second question is, why were the resolutions actual means of interpretation, or were they an attempt to regulate the treaty by its governing body? So while I think the second question actually answers better what that passage from the judgment was, let's start with the first one. So why would the court need consent to interpret a treaty? So if we go back to the VCLT here, we would see that there is no wording that requires all parties to actually make those subsequent agreements or subsequent practice. And actually, we see that there is this sort of language in regards to the conclusion of the treaty to clarifying what the treaty was at the time it was drafted. So if it had been just a very recent, if the treaty had been produced very recently, then we could use these methods highlighted in green here that require all the parties to show what they actually meant when they were drafting the treaty. But that's not the case with that convention. And if we go further in the VCLT, we see there is an article, obviously, about amendment of treaties. And the wording of that article is surprisingly similar to the subsequent agreements laid out in the interpretation. But as obviously, let me highlight this here. Okay, but obviously, these two things here, the subsequent agreement for interpretation and the subsequent agreement to amend a treaty, they cannot mean the same. It would be redundant. So that's how the court actually, how the judgment actually blurred the line between modification of a treaty, which would require consent, and subsequent agreement in regards to interpretation of a treaty. And the ILC, the International Law Commission, has hinted at the possibility that an interpretation can, after a while, lead to the modification of a treaty. But nonetheless, these are nevertheless different things. They are different things. Okay, trying to move to the next slide. Okay, so they are nevertheless different things, interpretation and modification of a treaty. So that begs the question, were the resolutions brought forward by Australia actually means of interpretation, or were they an attempt to regulate the treaty? And I actually believe that the latter is more accurate, because the wording of the resolutions, which I will not bring here, actually give so many criteria about how to define scientific research that it actually was way beyond the scope of interpretation. So in my opinion, what the court was trying to say was that this resolution here cannot be used to interpret a treaty because it is not a simple interpretation. If we go to any basic law book, it would say that interpretation is extracting from a text a given norm. But if the message that Australia was trying to extract from the text could not in any way be extracted without that resolution, then it actually isn't proper interpretation. It was actually an attempt to modify or give a new meaning to such text. And this is why I say that there has been a continuum between consent to be bound and treaty interpretation, which is more to be said, a blurring of lines between treaty modification and treaty interpretation, which does not only fall on the court, but actually on the parties and the way they handle resolutions in soft law. And that is why this is relevant to international environmental law, because in this field and also economic law, there are a lot of resolutions that are dealt with by courts and by lawmakers. So the boundaries between interpretation and consent, interpretation and modification need to be clear. Otherwise, this would lead to such confusing passages on judgments. Well, that sums it up, what I have been researching on. I will switch back the controls to Professor Gardner.
Louis, thank you. Thank you very much for a very concise and fascinating and thoughtful presentation. That I look forward to the questions and discussion afterwards. And our next panelist is also a student, Brandon Sinnott from Emory University School of Law. Brandon is a member of Emory's Turner Environmental Law Clinic. He will be a summer fellow at the Southern Environmental Law Center in the summer, and is also a staff member of the Emory International Law Review. So we'll turn the controls over to Brandon. Thanks for joining us. Can you just test your audio? Let's see. I am not hearing him. Try again.
Sorry, I had myself muted.
Okay, no worries, no worries. Okay.
Can everybody see me?
Yes, we can see you. We see your.
Okay.
Yep. If you go back, yep, we can see your screen and we see you. Thank you.
Okay, great. Well, thank you so much for the opportunity to speak and for adapting to the new times we're living in. I'll get to it. My presentation is based on a comment I wrote for my school's journal, International Law Journal. In my comment, I propose a treaty between the United States and Canada to propose endangered species, to preserve biodiversity. In today's presentation, I will explain key components of the United States Endangered Species Act and Canada's analog, and I will provide case studies to demonstrate how they could be improved by a treaty. Then I will give a brief overview of Migratory Bird Treaty, which is a precedent for my proposed treaty, and then I'll talk about my treaty very briefly at the end. So the United States Endangered Species Act has a few general provisions. The act broadly prohibits the taking of species that are listed as endangered or threatened species. And takings are defined as the sale, importation, exportation, transportation, harassment, harm, killing, capturing, or collecting of any endangered or threatened species. So pretty much just about harming it in any way. In the U.S., endangered and threatened species are also listed. The Secretary of the United States Fish and Wildlife Services determines whether any species is endangered or threatened, and it designates critical habitat, which is a habitat area essential to the conservation of a listed species to be preserved. The Secretary publishes a list of threatened and endangered species every 5 years to be reviewed. And I will highlight here that this process takes much time, more time than there really is to preserve much of the species in peril. And also the Endangered Species Act applies to private property and to government-owned land. All federal agencies must carry out programs to conserve endangered and threatened species and must ensure that their actions are not likely to jeopardize the continued existence of any endangered or threatened species or result in the adverse modification of species critical habitat. That's sort of generally how the Endangered Species Act works and still works. However, the Act was changed in August 2019 by the current administration, and there's a few substantive provisions that are really disheartening. For one, the new rule allows regulators for the first time to calculate economic cost when deciding whether a species warrants protection. This lessens the chance that the species will actually be listed. The new rule also redefines language that makes it easier for the Department of the Interior to neglect threatened species who are impacted by climate change effects. Excuse me, sorry. This is based on the definition of foreseeable future, which is used in defining a threatened species. The EPA also changed the definition of critical habitat to include only land where endangered or threatened species live, instead of permitting regulators to include land they once occupied and land they might occupy in the future, which is how the current rule worked. And it also removed the 4D rule, which kind of blanketly provided the same protections given to endangered species, also to threatened species. So it's kind of really hurt threatened species is the main takeaway here. And now quickly to Canada's analog, the National Strategy for Species at Risk. It does have 3 components, but most of the substance is in the third, the Species at Risk Act, and also in the provincial laws. Some of Canada's provinces have their own endangered species laws, but SAR takes a species-centered approach. It's administered by the Canadian Minister of Oceans and Fisheries and the Minister of the Environment. It applies only to federal land, which outside of the kind of sparsely inhabited north is only about 5% of Canadian land. And SARA also grants the federal government a discretionary power to regulate inside of provinces, but it has never used this discretionary power. SARA's listing is a little more expansive than in the United States. It has 4 categories. It has extirpated, which is extinct, endangered, threatened, and then it has a special concern, which is precautionary. It's saying that the species may become threatened or endangered. Another key provision is that the recovery strategy cannot consider non-scientific factors, which is different than the new United States law. And then to the provincial laws where most of the work is actually done, or could be done. There are a bunch of provinces without specific endangered species legislation. All of the ones, British Columbia, Alberta, Saskatchewan, Yukon, Prince Edward Island, and Nunavut. These provinces do protect endangered species through wildlife acts, but in those acts, the endangered species are not specifically targeted, and they're kind of general acts to protect species. Some of these acts list species, but do not protect their critical habitat, and some of the laws don't prohibit takings, and so have no teeth. The acts that do have endangered, or the provinces that do have endangered species legislation are Ontario, Quebec, New Brunswick, Nova Scotia, Newfoundland, and Labrador. These acts still reflect regional differences, and some have stricter provisions than others. For example, Ontario's law prohibits takings on private land, but many of the statutes do not do so and only apply to government-owned land and not private property. And now we get to the case illustrations. This one is about the Lake Erie water snake, which illustrates how increased coordination between the United States and Canada could solve implementation problems arising from both countries' tendencies to focus solely on species status on their side of the border. The Lake Erie water snake is a cross-border species living on these islands I have in between Ontario and Ohio in Lake Erie. The Endangered Species Act applies in the United States, and then the Ontario Endangered Species Act applies in Ontario. In the United States, the water snake was actually recovered in Ohio in 2011 and was delisted, but it remains listed and endangered in Canada. Canada's efforts to rejuvenate its own population are commendable, but there are so many species needing help in such a paucity of resources that it's inefficient, unfortunately, to focus on a species that is doing well, right across the border in the United States. There was a cross-border species initiative in the 2000s, but there was turnover at the institutional level and kind of fell through. Increased and sustained cooperation and increased information sharing between the United States and Ontario and other Canadian provinces is a simple fix that would allow Canada to delist the Lake Erie water snake and to allocate resources toward other listed species. And now for my second case illustration is about the sage grouse that lives in Western United States and also Western Canada. And I'm advocating for an ecosystem approach. The inability of current and recent endangered species legislation to protect the sage grouse illustrates the limitations of the species-centered framework that we have set up, because the political realities are that it's difficult to stop landowners from engaging in lucrative activities on their property in the United States and in Canada. In the United States, for example, the sage grouse was listed in 2010, but then was not listed in 2015, even though in the meantime, half of its historic habitat had been lost. The agency's decision not to list the sage grouse stemmed from its confidence in a 2015 set of management plans created in response to the 2010 determination that steered oil and gas development away from the bird's most important habitat. However, this plan was very quickly amended, which eliminated 8.9 million out of the 10.7 million acres of so-called sagebrush focal areas. They also loosened development-free buffers around the grouse mating areas, and in some cases, drillers can actually seek waivers to put well pads or other infrastructure in areas where surface development was previously off limits. So in the states, unless the courts restore protections for the bird, its environment is going to be continually weakened by oil and gas. And in Canada, there's a similar story. Nearly 90% of Canada's sage grouse population died off between 1988 and 2006 as a result of oil, gas, and other development. In the areas where the sage grouse spend the winter and breed and nest and raise their young. That being said, it's been on the federal list since 1998, and it's, the fact of being on the list isn't really helping. Eco-justice lawyers actually represented a bunch of nonprofits in Canada to allege that the federal minister of the environment acted unlawfully when he refused to identify the sage grouse's critical habitat as part of a recovery plan under the Federal Species at Risk Act. And in July 2009, the federal court actually did rule in Eco-Justice's client's favor and found that the decision to ignore the critical habitat of the greater sage grouse in the official recovery plan was unreasonable under Canada's Species at Risk Act. And the minister was ordered to redraft the recovery strategy, but given the species-centric paradigm and the comfort with business, not much has really changed. I propose an ecosystem-based approach, which would solve this. The convention.
Brandon, yeah, sorry to jump in. If we're just about out of time, if you could please conclude in about a minute.
Yeah, absolutely. So the ecosystem-based approach is a strategy for the integrated management of land, water, and living resources that promotes conservation and sustainable use in an equitable way. I'm going to skip my treaty slide and get to my proposed treaty, what I think should be in it. I think the treaty should mandate an ecosystem-centered approach to be implemented by both nations' lawmaking bodies, so that the habitat where the animals live is the center of regulation as opposed to the individual species. Additionally, there should be infrastructure for information sharing. Think back to the Lake Erie case. It should restrict the relevant agencies to only consider scientific data and not economic data. It should mandate that critical habitats or ecosystems should include considerations about the future, and it should mandate that climate change is in fact considered in determining where these animals will live in the future. Thanks so much. I hope it was helpful in some way. That's all I have.
Thanks, Brandon. Thanks so much. And let's see if Rui could also, if you could unmute yourself. David, we're going to ask you if you could just mute your video for a moment, and we'll take a couple questions here for Rui and Brandon. Richard, you have a question?
I do. Thanks, Roy. I actually have two. So thanks both for two great presentations, both really, really interesting in their own very different ways. So I've got a question for each of you. Firstly, to Rui. Great presentation. Really like your idea of this notion of the continuum. So I was just wondering where consensus decision making sits in on this continuum. It may not be something you've looked at before, but or maybe something that could take you off down a different direction. But for instance, decision making bodies such as CAMLA or that sort of thing, which you could then point out that really does reflect the motivations of the parties. And just to throw a little bit of spanner in the works, for a period of time, the International Whaling Commission started referring to its decisions or its resolutions as being consensus resolutions. And I think it only really happened for a couple of years, but it then makes me wonder, well, does that mean that they have additional power over ordinary resolutions? I suspect not, whether it was just semantics, but might be interested to think where this notion of having to build informal consensus might fit in on your scale. Brandon, really interesting stuff about on-the-ground conservation there. Really enjoyed your paper. And I was wondering whether you might just reflect very briefly on any lessons that the Migratory Bird Treaty has for transboundary cooperation between the US and Canada in that. I know there was a kind of a slide and things you were going to talk about that, whether you had some additional insights there. Thanks.
Thanks, Richard. So we'll go with Rui first and then Brandon.
All right. Thank you, Richard, for that question. I believe that if they are materially a form of consensus resolution, then they actually might affect these decision makers in two ways. Well, first, it will actually be more substantial, as the courts may actually feel more confident to use those resolutions, given that parties agreed to them previously. But in second, it actually might prevent litigation altogether. Because if parties already know that this is being given due weight by courts in reaching judgments, then they will actually either not agree to those or they will abide to what they agreed to.
Cool. Thanks very much.
Brandon?
Okay. And as for the Migratory Bird Treaty Act, in the United States and in Canada, it acts similarly to their established endangered species legislation. It just prohibits taking mostly. The act was mostly in my presentation to show that environmental treaties between the United States and Canada do exist. They've existed for over 100 years, and that they're not technologically difficult to do. It's more of a question of political will than anything else.
Thank you.
Great. Well, thank you both very much for your presentations. Ordinarily, if we were in person, the conversations would then spill out into the hallways and during the breaks. And so if folks do want to continue the conversation on the margins offline, and you don't have each other's contact information, just reach out to us and we will make sure that everybody gets put in contact with each other. But thank you again. Those were wonderful presentations, and thanks for joining us. David Wirth is a professor of law at Boston College Law School, my alma mater. He is a former attorney advisor for oceans and international environmental and scientific affairs in the Office of the Legal Advisor of the State Department, where he had principal responsibility for all international environmental issues. He is the author of more than 6 books and articles on international law, and he's a life member of the Council on Foreign Relations. And we're really delighted that you could join us to close out the conference. Thanks so much.
Well, thank you very much, Professor Gardner, as we're very proud of you as one of our outstanding alumni. This is a first for me. Actually, just before I went on camera, my wife convinced me that it would be very foolish to be wearing a tie under these circumstances. So this is the very first professional presentation I've ever done without one. It's unfortunate because it's a really good one. So you'll have to invite me back next year so I can appear in person in Florida. Professor Gardner asked me to speak about multilateral environmental agreements. As he said, that was my principal job description when I was at the State Department, the sort where you speak into the microphone, your words are translated into 5 languages, and hopefully your proposals are adopted by consensus at the end of the day, as one of the previous speakers pointed out. As I quickly learned, these agreements fall into a variety of categories. Although the categories, the borders are not entirely crisp, there are roughly 2 of them. One group dealing with natural resources and wildlife, which is the subject of today's conference, and another group dealing with pollution and public health. What I've tried to do in this presentation is to look at the 2 groups together to see what sort of learning can be distilled for the benefits of wildlife going forward. My goal is to identify a toolbox of possible mechanisms, innovative mechanisms, underutilized mechanisms that could be deployed in the future, given the impediments in international law to meaningful collective action. The cleavage between the environment, between public health and pollution on the one hand and wildlife on the other was driven home to me quite dramatically when I signed on to be a co-author on one of the case books in the field. After several editions, I managed to get a new portion inserted on risk assessment, which is the process of determining the hazards that are posed by toxic chemicals. As you can see from the slide, the principal animal in that story is the mouse. You've probably heard about mouse bioassays, where one takes 50 mice, splits them into 2 groups, the control group and the test group, exposes the test group to a variety of doses of the suspect chemicals, and then after 2 years examines both to see whether there are any tumors. Well, I managed to get a dose response curve on benzpyrene, a component of cigarette smoke, included in the new edition of the book. And then I was shocked to see that the caption identified it as not a mouse bioassay, but a moose bioassay. After the shock and the threat to my career wore off, it was several minutes before I could stop laughing. Could you imagine a moose bioassay, 100 moose split into 2 groups, one subjected to the suspect chemical? Well, it turned out that this was not a mistake at all, but in fact a correction inserted by one of my colleagues who shall remain nameless. It does tend to show the cleavage between what you might call the public health pollution side of the house, so to speak, and the natural resource wildlife component. And what I'd like to do in this presentation is to try to bridge the 2 of them. When I was in law school, I spoke to my professor and said I was interested in doing international environmental law. His response was, well, there is no such thing. Any number of decades later, that is far from the case. We actually have quite a bit of law, as the previous speakers have identified, on which to build and many models to choose from in our toolbox going forward. The simplest situation in international environmental law is transboundary pollution, where we have a physical transmission of a pollutant across a border. This is a plant known to every international environmental lawyer as the smelter at Trail, British Columbia. It's still there, operating under the name of Tech Cominco. It was sending fumes into the United States. There was no treaty governing the situation between them between the United States and Canada. And the border looked like it was a potentially insurmountable impediment to solving the problem. That turned out not to be the case, and with the help of customary international law, the problem was more or less solved and a precedent created. The important learning from the Trail smelter is that customary international law can play an important role. By the way, the facility is still there, polluting Lake Roosevelt, which is the reservoir for the Grand Coulee Dam. Second, and as was just mentioned by one of the previous speakers, is a situation dealing with shared natural resources, more along the lines of this conference. The model treaty in this area is one from more than 100 years ago between the United States and Canada, dealing with migratory birds. The incentive to overcome collective action problems is, I think, fairly obvious. If one side shoots all the birds, then there aren't any left for the other. Interestingly, to answer one of the questions that came up in the previous to the previous panel, the motivation for this treaty was not environmental or conservation per se. It was more economic, on the theory that migratory birds were useful in agriculture and in preventing pests. So customary international law, the Trail smelter, bilateral agreements on shared natural resources, such as migrating caribou herds between Alaska and Canada, many different sorts of applications there. Then we come to commons management, areas beyond national jurisdiction, where we move into a true multilateral area. This is a picture of the Pacific Garbage Patch, which lies in an area beyond national jurisdiction. It is in the high seas, in the middle of the Pacific Ocean, in an area where no state has jurisdiction according to custom and according to treaty. Other situations that present commons management problems are Antarctica, the stratospheric ozone layer, and of course, the climate. You can also think of public health, global public health, as being a commons issue. So for instance, COVID-19 is now a truly global issue involving the need for collective management of the common resource of our public health, about which more in a few minutes. So a number of issues are regional, such as acid rain, the acid precipitation transported over long distances, but not necessarily to the global level. This particular problem established a precedent in 1979 with the Convention on Long-Range Transboundary Air Pollution, which set up a model that has since been used many times over, the Framework Convention plus Protocols model. The 1979 convention now has something like 8 or 9 protocols. And in the wildlife area, the best example is probably the Convention on Biological Diversity from the Earth Summit in 1992, which has 2 protocols, the Cartagena Protocol and the Nagoya Protocol. By the way, that model is not demanded, it's not required by international law, but it has become something of an accepted model going forward. And then we have the truly global issues such as climate, as exemplified by the Paris Agreement. The 2 examples here, stratospheric ozone depletion, probably the greatest single success story in this field. The ozone hole over Antarctica will probably heal at some point during the century. And then on the other end, we have climate, which of course is a problem that has stubbornly defied solution at the multilateral level. And beginning in the 1990s, there was what you might describe as a second generation of issues that emerged in international environmental law, and that is the consequences of global economic interactions, such as trade. This is a picture of a turtle caught in a shrimping net, which was the subject of a dispute in the brought by Malaysia, Pakistan, India, and Thailand in the World Trade Organization against the United States. which had embargoed the importation of shrimp from countries that did not require turtle excluder devices in their shrimping nets. One of the problems in the trade environment interface, probably the single greatest problem, is that the trade regime looks at environmental measures of that sort, including those to protect wildlife, as in this case, all species of turtles are endangered, sea turtles are endangered. The trade regime looks at measures to protect environment, public health, and wildlife as impediments to trade, as barriers to trade that are subject to attack and potential removal. One way to turn this around is to look at those measures as contributing to sustainable development. So, for instance, if every country on the planet were to require the internalization of cost to the climate in the production of goods with fossil fuels, then my assertion is that the climate problem would be solved not through governmental action, but through market mechanisms. Maybe not entirely and maybe not relatively quickly, but we would certainly turn around the incentives and the dynamics in the international system more generally. Another juncture besides trade is foreign investment, where what is crossing borders are not goods in international trade, but capital. That's another juncture at which sustainability might be factored in, but has not. For the foreign investment regime also looks at environmental, public health, and wildlife protection measures as impediments to foreign investment. This is a picture of a gold mine in El Salvador, which is the subject of a dispute under the foreign investment agreement with the United States. Gold mines are particularly destructive to the environment, releasing cyanide into the surrounding waterways. And then the third is consequence of development assistance. Is development assistance helping or hurting in terms of wildlife protection, in terms of encouraging sustainability? Penetration roads into tropical forests, are those sustainable? And if they're not, how can overseas development assistance, such as that delivered by the World Bank in the picture, be turned around so as to encourage progress as opposed to undermining goals, wildlife protection goals? And then last, this is the line, Cameron from Brazil, endangered, and how do we deal with situations that have no obvious connection to the international system whatsoever? They're just endemic species located within the borders of sovereign states. That is the big challenge that the Convention on Biological Diversity seeks to address, largely through the creation of positive incentives such as funding. Okay, so what sort of remedial strategies have we encountered that might be helpful in the future? One is compensation through the Global Environment Facility, which is the multilateral fund that supports a number of international conventions, including the Convention on Biological Diversity. Another is overcoming collective action problems. We can see this in the United States right now, that some states are ahead of the curve, so to speak, in terms of lockdowns and social distancing. Others are bringing up the rear. How do we, in terms of not putting orders like that in place, how do we overcome those collective action problems by creating incentives for the laggards, for the free riders, for those that are holding out for the scofflaws? In international law, negative incentives such as punishments are of limited utility, so positive incentives in terms of rewards tend to work better. Reconciling competing policy considerations, again, harmonizing policies from one state to another with respect to wildlife management, with respect to social distancing in the current pandemic, and harmonization, another similar approach. Harmonization means to make similar or make the same. So financial mechanisms, greater citizen private party participation in international processes. This overcomes some of the difficulties that were identified by previous speakers in that wildlife and animals are not typically understood to be persons. If we were to create a process to produce remedies for wildlife, that's something that can be done through a treaty process and constructed through it. We have at least two examples. One is the World Bank Inspection Panel, a mechanism for reviewing the consistency of the bank's actions by reference to its own policies, and the NAFTA side agreement citizen submission process, which was just reinforced and codified in the USMCA NAFTA 2.0, creating more opportunities for citizens such as you, me, organizations that represent us, the World Wildlife Fund, to compel action by international bodies is a model that's out there but largely underutilized in this field. Others are private voluntary schemes mobilizing the public. The Fair Trade Coffee is an example of our Stewardship Council is another. Global Food Safety Initiative. Many countries have thin or non-existent food safety protections. This is all done through private mechanisms. And then appeals to the court of public opinion to shift thinking more generally. Against that, we have some, and I'm just about to wrap up, against that we have some unfortunate trends that tend to dampen some of these initiatives. One is the fragmentation of the state, devolution to other actors, and the creation of power vacuums. We can see that in the current pandemic, where states vary in their capacity to respond to the problem by compelling their publics to behave in a particular way, with failed states and states that have relatively thin governmental infrastructure likely to be unsuccessful at that. Another is, this one's very interesting, especially given that I teach at a Jesuit institution, the role of other non-state actors, and one in particular, namely Pope Francis. His encyclical letter right before the negotiation of the Paris Agreement revived a strain of public international law that was until that point relatively dormant, and that is the role of natural law, the role of moral philosophy. Interestingly, at the beginning of international law in the 17th century, the role of natural law, the role of moral philosophy, and the role of the divinity in correctly ordering global society was actually quite important. The Pope, with his encyclical, is at least arguably reviving some of those thoughts. The internet allows us to communicate as now, dramatically lowers information barriers. Supranational integration, such as the European Union, although it's an on and off thing, as we all know, tends to create the EU has now become an alternative power center on many public health and pollution issues, largely because it represents the collective action of 27 member states. And then intensified activity in international organizations. We don't hear that much about it in this country because our own government tends to be somewhat skeptical of it. But the United Nations and other international organizations have become increasingly active over the past decades. Impediments are, as in the COVID situation, as in the pandemic, as in wildlife preservation. It looks from the outside as if many of these agreements involve pain and no gain. There's a great deal of fragmentation among them. For instance, the strongest treaty to protect wildlife is the Convention on International Trade in Endangered Species from 1972, but that deals only with the juncture of trade, which is a very powerful one, but doesn't necessarily address the entirety of the problem. And then ineffective decision-making procedures, as the previous speaker in talking about whaling in the Antarctica mentioned. So we need to move towards more effective international decision-making processes, international organizations that are more effective, and a serious rethinking of molding and shaping private resource flows to reflect, for instance, carbon intensities. So as we talk about the moose, I suggest we also keep in mind a mouse, namely the animal that helps us to understand toxic chemicals and pollution much better, and maybe indeed they can both work together, as in this slide put together by the same person who identified the moose bioassay in the book. Thank you very much for the opportunity to speak today.
Thanks so much. Thanks so much, David. That was a great talk, a great concluding lecture for the conference. I think it dovetailed quite nicely with our opening lecture today by Linda Malone, taking a look at new tools in non-environmental agreements, and you brought out some of the underutilized mechanisms that are already existing in some in some environmental agreements, and focusing more on the positive incentives as opposed to the negative incentives. So let's see. So we have time for some questions and discussions. If anybody has a question or discuss, or you can either post it in the chat or the question box, or you can unmute yourself and just identify yourself. We had one person on now. Volker, did you want to say something? So let me ask you this general question, David. Sure. And this is actually in line with Will Burns' thought about this conference for students, and back to your observation, that your recollection when you first well, actually my question is more sort of a nice concluding question for the conference. So Volker, if you have a question or comment, why don't you jump in?
For a really brilliant overview. I wonder which of those perspectives particular you mentioned would you consider the most important for the future decade of wildlife law? Where do you see the biggest chances, particularly also with the 2030 biodiversity strategy, which is now just under our development at the UN level? Yeah, where should this strategy more focus on? Which approaches would you consider the most promising ones for this perspective for the next decade? Thank you.
Well, thank you very much for the question. Wildlife law, as indicated by the slide with the golden tamarin, is in a way the most challenging of the lot, because it's not necessarily inherently international in the sense that an international lawyer understands international. That is, involving borders, involving the actions of states. What about endemic species that are confined to one state? Whenever I teach international environmental law, the very first class is about this typology of a sort that I set out here, and it's students, I think, by the end of it are in general agreement that that's the most challenging. So that situation, almost of necessity, has to respond to positive incentives. They are in the sense of encouragements as opposed to punishments. So looking for opportunities to, and it's very difficult to say exactly what is going to be responsive to the needs of those states that have a high level of biodiversity and where the world has an interest in acting. Brazil, Indonesia, DR Congo. So those, I think, need to be tailored to specific situations. That having been said, I think that there are some general approaches that would move things forward that are tremendously underutilized. One is if you think about it all, many countries where we're concerned about biodiversity are capital importing countries. International investment law has been tremendously underutilized as a juncture as a condition for encouraging wildlife protection. As I said, it in fact looks at those sorts of measures as impediments. That was the situation in El Salvador, where environmental protection measures were challenged as inconsistent with bilateral investment treaties. Similarly, on trade, the World Trade Organization agreement from 1994 identifies sustainability in one and only one place, which is in the first preambular paragraph as a kind of mention in passing. If you look at the structure of these agreements, they do not encourage sustainability. What they encourage is deregulation. So both of those, I think, are junctures that need much more attention in terms of their impact on wildlife in situ, on endemic wildlife. And then the third that seems to be considerably underutilized is the citizen complaint mechanism. As I said, there are at least two examples out there. One is in North America under NAFTA. That's only 3 states. It doesn't seem to have been used as a model in other settings. And the other is with respect to the World Bank after what were a series of tremendously disruptive scandals, and then need for some sort of external review mechanism was established. But organized legal mechanisms for citizens to pursue, and when I say citizens, I mean not just individuals, but organizations, nonprofits, what have you, to basically anybody to pursue, to draw these issues out before the public and have them publicized is, I think, would be helpful. So those are, I think it's something that requires tailoring for particular circumstances, but those are some thoughts as to where the potential for further growth might lie.
Yeah, so the Escazú agreement, for example, in Latin America, which is based on the European Union or European Hours agreement, yeah, that could be quite a good blueprint for the last point, which you also said, that such regional agreements of public participation, which give procedural rights to NGOs, to individual citizens, could be also a good blueprint for other continents, actually. Yeah.
Right. Well, in fact, is in Europe, there has been considerable progress in the form of the Aarhus Convention, which just deals with issues such as public participation at the national level and release of information, such as the U.S. Freedom of Information Act and that sort of thing. That is a model where, if it were to be replicated in other regions, including, by the way, North America, would be, not so by the way, in North America would be very helpful. There's a maxim from Justice Brandeis that sunshine is the best disinfectant. Getting these issues out in the public in a systematic way has been shown over and over again to have an impact on governments. So, for instance, the citizen complaint mechanism hasn't had, in NAFTA, has not had a tremendous impact on the United States, but it has in Canada in a different sense, in Canada and also in Mexico. The Mexican government has paid very close attention to these, and in fact has treated them as if they are a cooperative mechanism for identifying problems and moving forward collaboratively.
Thanks. Those are some really great points and observations to make, and good ones to end on. And I'm going to take the moderator's privilege here and ask the last question of the conference, and that is hearkening back to Will's original vision for this conference and your recollection, David, on what you were told when you were a student, that there was no such thing as international environmental law. What advice do you have for students who are interested in international environmental law or international wildlife law?
Well, first of all, pay, and we're talking about law students?
Yes.
Although
Although it could be it could be broader than that.
Mm-hmm. Well, first of all, for law students, pay attention to your torts and contracts in the first semester and get a good grounding as a lawyer before looking on to something else. A lot of times I see students who are so enthusiastic that they want to skip over some of the basics, generally not a particularly good idea. The other is to use every opportunity that comes your way during your education, during the summers, to consider yourself as a work in progress, building a resume not just for the sake of building a resume so that somebody will be impressed when he or she sees it, but building a resume that fleshes out your experience. So, for instance, working in international organizations in the summer, working in nonprofits such as, and I'll put a plug in for my previous employer, the Natural Resources Defense Council. What I always tell students is if you're not a member, your parents probably are. And also in government. The state and local governments present tremendous opportunities. So while you are maybe not in your first year of law school, but not in the first semester, but after that, look for opportunities to work with our students work with the Attorney General. They work in the State Department of Environmental Protection as volunteers. Those mature into summer jobs. Those then mature into internships during the school year, hopefully connected with, I don't know what the situation is at Stetson, but at least at Boston College, there are semesters in practice that can be put to very good use in terms of creating a springboard for a future career. So look for opportunities to pull the levers, be creative, find your own way, don't wait. And then last, there is inherently a great deal of frustration and disappointment in pursuing a career in this field. I felt it personally. I think I applied to the State Department 4 or 5 times before I actually got a job. And be persistent, be prepared to accept setbacks. When you're told no, you should understand the speaker or the message as coming to you is not necessarily never, but not yet. So good luck to everybody who's interested in this field. And by the way, I'm always available for consultation.
Thanks so much. So that's great advice and a wonderful way to end our conference. And so I just have a few closing remarks. I'd like to thank first of all Aaron Okino and Damon Johnson. Without them, our move to an online conference would not have happened. So really, I cannot tell you how much I appreciate all of their time and effort that they put in to make this a reality, a virtual reality, but a reality nonetheless. And I want to thank all of the participants, all of our speakers from today and yesterday, all of our attendees. Great question and answer and discussion. Apologize if we didn't have enough time to get to them all. We've tried to capture those questions. We'll pass them on to the speakers. And again, if you would like to link up with anybody from the conference, please just let us know and we will put you in touch. I think one thing that this experience demonstrates that international wildlife professionals are a community. We are a community. We're online at the moment, but we will be a community meeting in person again in the future. And as we noted, we are looking to have our next in-person conference at Cardiff University in Wales with Richard Cadell. And so at the appropriate time, we'll come out with some details and planning for that. And next in the queue after Cardiff is Charles University in Prague. So I hope to see you down the road. In the meantime, everyone take care, be safe. Thanks.